Mr. Bosman?
Justices of the
Is it fair to assume that you'll need your 10 minutes?
Yes, no, I waive the 10 minutes requirement. So there's just a brief introduction. Will take 2 minutes. Then I'm waiving that 10 minutes prerogative. Chief Justice, without repeating, much has been said during argument and debated. I think everybody present is aware of the highlights and the gist of the matters before the court, and more particularly the provisions of the Electoral Act, more particularly Section 8.3, that requires a person that must be entered into the voters' roll for voting is a person which is ordinarily resident and for no other voting district, only for that specific district, which coincides with Section 16.3 of the Act, which has been debated extensively in this court. Now, as was already said and argued, all legislation must obviously be interpreted in the light of our Constitution and in the light of free and fair elections. And when a voter's roll is incomplete, like the voters' roll in respect of the independents that served before Justice Weppener and the other honourable judges in the Electoral Court, such roll cannot be above suspicion or above the requirement that it should have the effect that a free and fair election process is to be taken place. And we submitted in our heads of argument, and we referred to various of the paragraphs in the decision of COM, where it was clearly underlined, Chief Justice, that the object of this particular section 16.3 is to allow candidates not to only detect who are the voters exactly on the roll, but they need to have the opportunity to canvass, to make contact with the specified voters. And it was not in COM a question of new law that was created, as was raised by several of the justices. It was an interpretation of existing law, existing since 2003. So the obligation we submit that rests upon the IEC already exists since the introduction of this law. And even before that, the whole purpose of the Constitution and the Electoral Act, Sections 7 and 8, requires that each voter has to vote in the specific district and ward where he is ordinarily resident. And if gaps or the absence of addresses in the voters' roll is merely condoned, so to speak, we submit that that would be contrary to the purpose of the Constitution and the purpose of the Electoral Act. Mr. Chief Justice, that is the summary of our argument. We have addressed it fully in our heads. We have proposed a solution, or as was put by the Deputy Chief Justice, a possible solution. And that is a fashion to remedy, as put by the Honourable Deputy Chief Justice. Fashion to remedy we have dealt with in our heads of argument by referring to Section 7 of the Municipal Electoral Act. And this section deals with registrations, applications, and I'm not going to read through the whole. It is well known to the Honourable Justices of this Court, but it deals with the fact that where a person claims that he has been registered, but his name is not on the roll. There's a certain procedure that can take place. We don't submit that this is without any flaw, or the splitting of the rolls is without saying the intention of the Constitution, but it's a merely temporary measure to endeavour to furnish a remedy if this court is inclined to grant the direct application, which we submit has no merits. And whilst on that score, just in brief summary, the direct application deals with time frames and deals with the inability to timelessly comply with the obligations of the IEC themselves, which we submit, and as we addressed in our heads, they created that themselves. But there has to be a solution either.
Mr. Bosman?
He's still within 10 minutes.
Oh, I thought he said once he's done with his
Are you
outline.
done? I thought you were wrapping up
Yes,
the remedy
yeah,
part.
I'm done. We can.
Oh, very
I'm
well,
done.
very well.
Yes.
Thank you. I don't understand how one can use Section 7 for these purposes, because that, in so many words, is or concerns a situation where somebody is not on the voter's roll.
Yes.
But they are seeking to vote on the basis that they had applied. Now you are seeking, on the basis of that section, to have people removed from the roll. That section is just not meant for that situation at all. And added to that, once somebody is registered as a voter, they have an untrammeled right to vote.
Yes.
So why subject them to the Section 7(2) strictures,
Yeah.
and which are made worse by regulations 5 and 6 on the processes that then have to be followed?
Yes.
Is that legislatively possible at all?
Well, Justice Mhlanga, we have considered that difficulty, and that's why we agree from the outset that we don't say this is an out-and-out solution without any difficulties. That is one of the difficulties that is implied in the wording of Section 7(2). Now, the only submission that we can make in this regard is if one has regard to the fact that this is a mere temporary measure to obtain addresses. And that is only in the event we submit that the main direct application succeeds. If the direct application does not succeed, we would submit it should be dismissed with costs. Well, we are seeking costs, and I will address you, this court, very briefly on that. And that
Sorry to interrupt your answer, Mr. Bosman, but at an appropriate time, won't you just spell out for us what you think the implications would be if the court doesn't intervene to grant the IEC direct access? Just spell out for us in very simple terms what you think the come judgment would mean. Is the minister and is the INC and the IEC and the ANC correct?
Yes.
Maybe you would want to go there after this question. Maybe you would want to go directly to that point after this question.
Yes. Yeah.
What is it about Section 7, subsection 2 that you rely on that properly entitles this court to deregister people who have been registered? That's the first question. A related question is, in circumstances where you don't have anything in your hand to demonstrate that they were improperly registered, what is it in law that allows us to remove those people from the roll, voters' roll?
Well, we must concede that is one of the flaws that I initially referred to, and the only submission that we can make in this regard are already made. And if this court is inclined to use the mechanism of Section 7(2) just as a temporary measure to split the roll, so to speak. But we accept that it may have difficulties in regard.
Let's clear it up, because you see, we just want to make sure that we understand your argument, and if we don't, clarification is called for.
Yes.
Is there anything about Section 7, subsection 2 of the Electoral Act
Yes.
that, correctly interpreted, empowers this court to do what you propose should be done?
Yeah.
Really?
Yes, that is correct. That
Is there anything?
Well, the object of 7.2 was obviously what the wording, the grammar, means to say.
It doesn't apply to this situation, does it?
No, we must concede. We raised this point as we already submitted, as already stated before I get to the question raised by this court, and that is only in the event that this court can reach a temporary measurement, if, and that is only if, the direct application would succeed. And
I don't want to belabor the point, but we can only do that which the law allows us to do. And my simple question to you is, does this section allow us, does this law allow us to do what you submit we should do?
Well, we must admit, in the context of this section in the Act, in the Municipal Act, Electoral Act, that the purpose of the section is not what we submit.
All right. Now, my brother has put a question to you. What is the solution? Let's try to find a solution.
Yeah, if I understood the question from Justice Cameron correctly, the COM decision, and more specifically paragraphs 62 and 63, and we dealt with the relevant paragraphs in our heads of argument, had into mind interpreting section 16.3 that the municipalities' elections are required to be determined in wards, specific wards, and the process is vulnerable to manipulation. In other words, if voters can be brought from outside into a ward, or where political balance is unclear, few votes may influence the outcome of such election. And that is why we submit, in the light of the constitutional requirement of fair and free elections, section 16.3 was coming into operation in December 2003. And there's no other way to determine the purpose of that section we submit. It is clear on the face of it, and even before this section came to light, we submit that it was envisaged in the Constitution and in sections 7 and 8 of the Electoral Act that with regard to wards in municipal elections, the voters that had to be voted, that was entitled to vote in the specific wards, are the voters ordinarily resident in that ward.
You can round up before I come with my...
We submit, Chief Justice, that there's no merit to the appeal with regard to the direct access application. We also submit that there's no merit to that as well.
Yeah. On the assumption, and let's accept it for argument's sake, that the IEC's position is simply this. We meant well when we registered people from 2003, because I think that's the argument. We meant well.
Yes.
Not to include the addresses. We simply did not think that the recordal of addresses was such a critical component of the overall requirements that we did not include them.
Yes.
Now, seeing that we meant no harm, people are already there, they've been voting in that fashion over the years. Let's look for some common ground. How can we accommodate How can we resolve, rather, the problem? What would be your submission? And accepting that it won't be possible. For the purpose of, let's confine it, well, no, let's not confine it. For the purpose of the 2016, and you can deal with them differently, 2016 and 2019 elections, we will not be able to have addresses appearing against the names of those whose addresses are capable of verification. We won't be able to do it. What then must we do now that Section 7.2, the Section 7.2 option has fallen off? What is it that we must do to resolve the problem?
Well, the only other possible solution is possibly not viable, because a postponement, a further postponement to effect time.
Exclude that one. Exclude a postponement. What is it that we can do to ensure that the elections do happen as scheduled, without closing an eye to any law that applies
that is a very difficult aspect raised by you, Chief Justice. The problem we have with the version of the Commission is their opposition to the application before Electoral Court was on the basis that.
I missed the first part. The problem that you have with their submission is?
Well, to answer your question, the problem we have with the version of the Commission in the Court quo was that they proposed that the calm judgment is prospective, which is not. If one reads subparagraph D, 6D, it means that the candidates must be provided with a row with all the addresses where available, not available on the systems, where they can, as put by you, Chief Justice.
Well, let's assume that they are
ascertainable or ascertainable practically.
Let's assume that they are wrong. Let's assume that they were required by Section 16.3 to record those addresses, but they haven't.
Yes.
What then is the solution to the problem that would ensure that the elections are held as determined? What is it that we must do? Remember, you must assist us. That's why we put in so many questions to you. What is it that we must do?
The only submission that we can make really is that they don't bona fide take this court into their confidence if one has regard to their version of time frames and all that postulations. If the main application is dismissed, they must just do their work. And they must just go out and perform what they should have done already in from 2003.
When will that end? And what if they are not able to do that by the time we have the elections in 2016, August 2016? What if the process is not completed by 2019?
That is
what is it that must be done?
Great difficulty that they are faced with. And I don't want to repeat myself by submitting that they created the problems themselves. But that is indeed a problem that they are faced with. And
well, let me ask you this one. I think I put it to Mr. Marcus. I need assistance from you. The IEC, I know you don't represent them, and their submissions read with those of the minister seem to boil down to this. None of the 17 agencies whose assistance was solicited either by the IEC or the minister, which include, by the way, Statistics South Africa, are in a position to assist the process in a way that would result in all the addresses that are capable of ascertainment being ascertained and duly recorded before even the 2019 elections.
Yes.
Now, out of ignorance, and I ask again, I don't know these things. Yes. How long does it ordinarily take Statistics South Africa to conduct a census. You know, they come to your house, they put a sticker to show that they've been to this particular house. The next one, the next employee must not try and get the details because it's a job that has been done already. How long does Stats SA require to complete the process so that we can think through what the combined forces of the IEC and Stats South Africa are able to do? And if out of ignorance we assume that Stats SA might be of assistance when in fact it can't be of any assistance, let there be an explanation as to how impossible a task it is for both Stats SA assisting the IEC and the IEC with its 50,000 people to complete the process. Just help us there.
Yeah. Chief Justice, that was dealt with in our heads as well. The figures of non-available addresses or addresses which is not properly descriptive is at the moment 12.1 or 12.2 million. But in relation to a question put by yourself, Chief Justice, the census is usually done within a few months. And we submit, having regard, and we will almost submit the obstructive stance throughout these proceedings, and I don't want to get personal towards anybody, but they were obstructive with respect. They should come out of their corner and identify whether today or within a few days or within a week, which internet procedures or which whatever they can use through the internet or through the cell phone procedures regarding RICA and FICA, what exactly can they use? But to expect that they're going to bona fide answer that is a different question.
I thought, I don't know if they were obstructive because of their own accord. They did something which is somewhat embarrassing, and that is to admit that, you know, we had so much so that we identified over 1,000 people that were irregularly registered.
Yeah.
If you are not cooperative, if you are being obstructive, would you come up with those details of your own accord?
Yes. If I might just refer to... my learned colleague argued that 7 million voters doesn't have addresses, with reference to volume 5 on page 421 and 422. Volume 5, pages 421 and 422. That's a table that they dealt with in paragraph 66 of the answering affidavit. Now, it is clear from the answering affidavit that these addresses are unavailable in their system, not unavailable as objectively spoken. So if they could afford to, with 2 weekends promotions to reach approximately 4 million voters, what more can they do if they really go about and canvass and advertise? I know they plead poverty, so to speak, but they should just go ahead and do what they are required to do since 2003, we would submit.
You have familiarized yourself with their explanation, haven't you? You have familiarized yourself with their explanation in relation to the difficulties that confront them in this regard.
They raise a lot of difficulties.
What is it about the difficulties they outline that you believe is questionable, is of no substance?
Well, the mere figures that they were able to reach through the 2 weekends during April and March, proving that about 4 million, if I remember the figure correctly, addresses were obtained. 12 million can maybe be reached within a month. I know we are speculating here, but they should do their function properly. Chief Justice.
Mr. Bosman?
Yes.
Mr. Bosman, this side.
Sorry, Mr. Justice.
I'd like to come back to the appeal.
Yes.
I just want clarity on what your case was in the Electoral Court. Was there a breach of Section 8.3? Was it based on a breach of Section 8.3 or of Section 16.3? And what was the exact, what does the breach consist of in relation to either one or both? In other words, what did the IEC do wrong? Very briefly.
Well, the lack of the voters on the list, and it was, I think there was a typing error at some instance referring to a Section 18.3 where it should have read Section 16.3.
So I just want to know, as I read the Act, Section 8.3 creates the obligation on the IEC to ensure voting in correct districts.
Correct.
Section 16.3 creates an obligation to provide addresses to political participants in the electoral process.
Yes.
Now, I want to know on which one of those two sections do you rely, which one was breached, and how were they breached? What did the IEC do wrong in each case?
Yeah, the main course of action, so to speak, Justice Fruneman, was Section 16.3, and it appears from the Wepener judgment as well. And the lack of addresses, that was common cause. I think the Commission even mentioned a bit higher figure, but the figure is not, we submit, important. The fact is there were quite a lot of addresses that were lacking in the voters' roll. They couldn't canvass properly, and they couldn't properly function as spelled out in the COM matter in the relevant paragraph 60 onwards that we refer to in our heads.
And is it clear from the papers, please help me, that the alleged lack of addresses related only to post-2003 or even before that?
It was not, if I might just speak to my junior. Justice Fruneman, apparently no mention was made to that specific aspect. It must be remembered that an urgent application was brought. And I think it is also canvassed in the papers that literally a few hours before the start of the proceedings before the Electoral Court, the answering affidavit of the Commission was filed. So
I'm not asking for a justification for the papers. I just want to know what the case on the papers was. Yeah. And do I understand you correctly that on the papers it wasn't clear whether your case was breached only on post-2003 breaches or even breaches before 2003?
Yeah. Justice Fruneman, it seems to be that that particular issue, as I told you, was not clearly, was not canvassed at all before Justice Wepener and the other justices of the Electoral Court. But whilst on that, much debate has
I'm sorry to interrupt, but do I understand you as a matter of law today you restrict your submissions only to post-2003?
Yes. Yes, that is correct. And the lack of there was, as was put by, I think, Deputy Chief Justice, the Electoral Court was also challenged before the Electoral Court to answer that allegations and to raise a defence if they could, which was not done, we submit. So there was, in our submission, nothing wrong in the judgment of the Electoral Court. Unless there is anything else, the last aspects that we will briefly refer to.
Mr. Bosman, could I just get clarity on the impact of your case? So you would say that if any voter doesn't have an address where it was available objectively, that voter should not be able to vote in the upcoming local government elections?
Well, if the roll doesn't contain an address, does not mean he can still register, he can still go to the station and register.
Subject to your Section 7 solution.
Subject to the Section 7 solution.
And if the Section 7 solution, on the basis of the concessions you made in the debate with Justice Madlanga and the Chief Justice, doesn't apply, then what? Do you say that those voters shouldn't be able to vote in August?
Well, we don't say that. We don't say that. If there's any measurement or any solution to the problem, the aim of the Constitution, and we are 100% behind that, is to let everyone that is eligible to vote during the elections. That is the main.
So you're not opposed to the court trying to craft some constitutionally and statutorily responsible remedy on the basis of the evidence before it?
On the contrary, Justice Cameron, we initially thought that the solution offered by my learned colleague for the IFP was a possible solution. We considered that, and we also considered 7.2, which we proposed as a mere proposal. But we are 100% for some sort of a solution.
Mr. Bosman, two questions. The first relates to the application for leave to appeal and the appeal. On your case, if the appeal fails, what would be the consequences?
If the appeal fails, then comes into play the question whether the direct application should be allowed or not.
What would it mean for voters who are on the roll without addresses reflected?
Yeah, no, we have considered that proposition, Justice Masaneki. If
a matter of law,
yeah, it's a matter of law.
If the appeal fails,
if the appeal fails, the only application that is still alive is the direct application. Now, if the court comes with some or other solution as raised by Justice Cameron, whatever this...
You have the solution already. I'm still talking about about the appeal. I would like to know, what do you say the consequence of the electoral court judgment is for voters whose addresses don't appear on the voters' roll since 2003? Well, what is the consequence of the judgment, if any?
Of the electoral court's judgment? Well, the consequences is the elections were postponed, and the certification was set aside, so the elections couldn't go on.
Okay, we're struggling, aren't we? Let's start again. Let's try it bit by bit. Section 8.3, read together with 16.3, has appeared from the debate between you and Justice Froneman. The one imposes a duty to vote in the correct district, and the other a duty that the IEC should ensure. And 16.3, of course, requires finishing of the roll.
Yes, yes.
Do you agree with that?
Yes.
We have before us an appeal against the decision of the Electoral Court. And the basis of the appeal is that on its reasoning, it has made the entire roll vulnerable to the extent that there are voters whose addresses do not appear. And by implication, IEC would have to find all the addresses of voters who do not whose addresses don't appear. Is that your understanding of the effect of the Electoral Court judgment?
That's how we understand it, yes. Obviously, in interpretation of the COM matter as well, because the Electoral Court intended to follow COM, obviously. And where addresses are available, not as meant or as argued by my learned colleagues for the Commission, if it's in their system, if it's easily ascertainable or ascertainable, practically speaking, they must get those addresses.
I agree with you that available means objectively ascertainable.
Yes.
Then those who appear on the roll without addresses would be barred from voting. Is that your legal reasoning?
Deputy Chief Justice, and I'm saying it with all the greatest of respect, this court finds itself in the proverbial sense between...
Let's stick with the law for a moment, please. Let's just unravel the law. We can come back to our difficulties and so on. What do you understand the Kham judgment to mean?
Well, the Kham judgment is in our submission clear.
And in particular, does it mean that all those who have no names recorded against their names may not vote?
Yes. Well, if their names are not on the roll, it means, with respect, as we interpret COM, and more particularly the passages that I briefly referred to, that the roll, the voter's roll, is suspect, so to speak. And to go ahead with elections on such a roll would be contrary to the intention of the Constitution and with the intention of the Electoral Act, more particularly Section 16.3.
What do we do with the qualification that says, if available?
If available, as with respect put or raised in questions by the Honourable Chief Justice, if it's practically or easy ascertainable to get those addresses, they must get it. It will well mean that the situation that was created since 2003 until now, the inaction by the Commission, created a situation which is an unfortunate situation, but eventually the elections that goes ahead should be free and fair. And if there are a lack of addresses, if I may use this example, a ward that was created, so to speak, after 2003, on the version of the Commission, they would contain most probably most, or if not all, the addresses when they registered the voters. The wards that was created before that would not contain all the addresses because 16.3 only came to see the light in December 2003. That is the one situation. The other situation is where voters go from the one ward to the other or from the one district to the other. If there are no addresses
If the appeal succeeds, and then what would be the legal position?
The legal position is then that it means that the Electoral Court's decision is set aside and probably the elections will go ahead. That's how we see it.
I'm not talking about the elections in Tlokwe. I'm talking about the legal consequences. If we were to set aside the Electoral Court's judgment, what would that mean?
As we interpret it, Deputy Chief Justice, it will fly in the face, so to speak, of the COM judgment and the interpretation of the relevant laws, more particularly Section 16.3, if the appeal would succeed.
I don't understand most of the submissions you make, but I hear you. Thank you.
Well,
thank you.
Something just dawned on me. If at the end of the day we accept the IEC's explanation,
yes,
that it is unrealistic it is impracticable to have the addresses ascertained and linked to the names that don't have addresses on the common voters roll before the elections are held in August.
Yes.
Why does that not accord with the construction of where available that suggests
Yes.
that those are the addresses that are not available? And because they are not available, you don't have them to be able to furnish the parties with them before the elections are held.
Yeah.
It is unjust to make an order that says, do it anyway because you are supposed to have done it from 2003. It's not just equitable to make an order like that.
Yeah.
What's wrong with that argument?
Well, we submit that the position is that, to put it the other way around, to endeavour to answer your question, Chief Justice, is if they take action immediately and get more addresses in compliance with 16.3, they would at least minimise the effect, the negative effect, at least.
I don't understand the IEC to be saying, we now appreciate the need to obtain addresses, but we're not going to do it.
Yeah.
I understand them to be saying, we're working towards that, but it won't be possible for us to accomplish that mission before the local government elections are held and before the 2019 elections are held.
Yes.
Now, are those addresses available within that context then?
Sorry, Chief Justice, are what available are they?
Those addresses which it will require a long time to ascertain available for the purpose of compliance with Section 16.3.
On their version, it seems not to be possible to obtain those addresses. But as we submitted, at least they can minimise the negative effect.
Well, on that understanding, is it appropriate to then say, the addresses are not available, but do what you can in the meantime?
Maybe say they should be ordered and they must come to with...
I beg your pardon? I need your assistance, Mr.
Yeah,
Bosman.
no, I know, Chief Justice.
Yes.
Yeah, I think they should be put on terms. If the direct applications succeed, we would submit that they be put on terms.
Okay, so you, in principle, you are not averse to finding a solution along those lines?
No, that's why we proposed.
Okay. What are the terms?
Say again.
What terms must they be put?
Well, they put certain proposals to this court, which is totally, we submit, we cannot challenge that, but it is proposals that's not practical, it seems. If one has regard to the 2 weekends during which they endeavoured by advertisements on the radio, etc., to make contact with voters, and in the process they reached approximately 4 million voters.
What then would be reasonable in the circumstances in view of the concern that you have that they are able to do something, they ought to be able to do that which they are able to do? What are the reasonable terms that we must that you propose with that understanding?
Yeah. Well, we know, Chief Justice, that the voters' rolls are to be certified by the end of this month, we understand. So we have little time, but there is still time. Now, whilst on that score, so to speak, yeah, we sought in our heads of argument dismissal of the leave to appeal, and in the same vein as the IFP, if leave to appeal is granted, to dismiss the appeal with costs. And the direct application also stands to be dismissed, we submit, with costs.
Let me ask you this question. Is it open? Do you think, is it a reasonable a proposal to make to the parties that, well, judgment will obviously be reserved, that between now and the production of the judgment, if we have to get to that point, parties try to reach out to one another and find what you call a reasonable,
Yes.
or reasonable terms that could then be furnished to the court to consider, all designed to ensure that the elections happen,
Yeah.
but subject to an effort be made to comply with such legal requirements as might not have been complied with within the time available to them, to do the little bit that they can do.
Yeah. Chief Justice, it seems that this particular case before this court enjoys wide coverage in the media. If they could once again proceed possibly to advertise by SMS and on radio and possibly television. And I know my learned colleague addressed you on the lack of funds, but we submit that it is one of the proposals that maybe, or one of the campaigns that may be considered that is fairly quick and fairly effective, having regard to the recent history.
Yes, I'm asking whether the parties can find each other, can make an effort to find each other in the interim. Is there room for that, or have you explored all available avenues? You just can't talk to each other, you just can't find a solution to this problem?
We may definitely endeavour to do so, Chief Justice, and it will be in the interest of everyone concerned, we would submit. Then lastly, the question of costs, I'm not going to address you fully on that.
Before costs, Mr. Borsman, I just want clarity on a response you gave to a question by my brother, Justice Froneman. You said, as of today, you are only looking at the obligation insofar as post-December 2003 registrations are concerned. What, or rather you say your case, yes, concerns the obligation as from that date. I'm not sure that you actually referred to which registrations exactly.
Yeah.
What arises from your response is this possibility. It may mean that you are saying the obligation itself arose under Section 16.3 with effect from December 2003 or after December 2003. But how that is then to apply is not necessarily that only addresses, the obligation is not necessarily that it addresses post-December 2003. What exactly is your point? The obligation starts from December or post-December 2003 and applies only to registrations post-December 2003, or the obligations comes to life then, but applies to pre- and post-December 2003 registrations. What exactly is your point?
Justice Malonga, on the papers, it's clear our version, our client's versions are that not only new registrations, since either the COM judgment or post-2003, all voters' addresses can be obtained. Pre- and post-2003 must be obtained. That is the purpose of the Act. And that is the only real purpose that can really effect an election that is fair and free, if that can be reached. And I know of the difficulties that the Commission has, but that is how we interpret the Act, and more particularly Section 16.3, Justice Matlongo. Unless there's anything else, thank you very much.
Thank you very much, Mr. Bosman. Mr. Katz, while you are settling, which issues are you going to focus on?
The DA submits that the appeal, such as it is, because I want to come to it in a second, should not succeed. In order to analyse that, we would ask the court to turn to page 377 of volume 4, where the order appealed against will be found.
Are you going to insist on your 10 minutes or not?
May I ask for 5? May I ask for... Thank you, Chief Justice.
What page?
Page 377. I'll come to that in a second. That's as far as the appeal is concerned. I'm going to turn to page 377. One sees the amended order made by the Electoral Court, and we will submit that the appeal should not succeed. But I'll turn to that in some detail. As far as the second, more difficult issue is concerned, assuming the appeal does not succeed, the question is, what does the court do? And that's a more difficult issue, which I wish to spend a little bit of time on. As far as the second leg is concerned, the Chief Justice had a debate with our friend for the Minister. And the debates, as we understood it, centred around the question of where does the court get the power to make any order that is just and equitable on the particular facts? And we would submit that there are two legs. One is the court has the power by virtue of Section 172(1)(b) to make any order that is just and equitable, even in the absence of a 172(1)(a) order. And for that we rely on the Ermelo case, as well as Minister of Safety and Security versus Van der Merwe, a judgment of the Chief Justice before he became the Chief Justice.
Are you hitting me with my own judgment?
If that's how you see it, Chief Justice, yes. But the issue is this. If I understood the debate, it was this. In order to find a 172(1)(b) remedial order available, there needs to be some understanding or finding that there was unlawful conduct by someone. On the papers, the court can find, and must find, we would submit, that the IEC have acted unlawfully since, on their own version, December 2003. So once one has that unlawful conduct as a foundation, this court is then free under 172(1)(b) to make any type of just and equitable order, notwithstanding that there's no 172(1)(a) order that is to be made. And that's what Van der Merwe, your Chief Justice, that's what you said in Minister of Safety and Security versus Van der Merwe. As to that second leg, we will ultimately propose an order along the lines, well, not an order, propose a suggested solution along the lines of the parties coming together, but in perhaps a more nuanced and difficult way. We would invite the court to invite or order the IEC and those who support the IEC's version of events to propose to the court within a few days or a week an order that they would see as just and equitable, on the assumption that the appeal fails, but not the order that they've asked for, and give the other parties an opportunity to respond to that order. And the reason I say that is because through the debate that's come through today, one sees that the 16.3 purpose has twofold. We know this from COME in any event. The one is the functional utility of canvassing, and secondly of verification. Now, on the IEC's version, canvassing is to protect the canvassing functional, I've lost the word, purpose. It's going to be impossible on their version. Verification, not necessarily so, because there could be some mechanism that the IEC could put in place that those who turn up to vote, whose addresses are not on the voter's roll, provide proof, and not along the lines of the IFP's version, but along some other lines, that they provide proof of their address at the time of voting, whether it be a Vodacom, perhaps that's given last week's judge, now, a cell phone type address, a FICA type address at the voting station at which they are, so that there can be a protection of that second functional purpose of 16.3, which is a verification, coupled with the type of order well, the potential for the type of order which could set aside a particular election in a particular ward were a particular set of candidates or parties to approach a court, the electoral court, to suggest that there had been the kind of difficulties that were experienced in Clockware. So that's broadly what I intend to deal with. Let me turn to the appeal first. On page 377, one finds the order that, and Chief Justice, I suppose the few minutes that are asked as the window, I will waive going forward.
You want to waive?
A waive from now.
Yeah, no, then let me zoom in then. You have reminded us, indeed, of two judgments, one by the Deputy Chief Justice and the other by me, where we said, quite frankly, I had forgotten, where we both say, you need not find that there is a law or conduct that is inconsistent with the Constitution before. You can make a just and equitable order in terms of Section 172. Now, that opens the possibility for crafting an order that could facilitate the holding of elections, notwithstanding the challenges that are there.
That's right.
Maybe let's focus on that possibility.
Yes.
What in relation to time frames, if the 4-year or so period were to be found to be unreasonable, what period would you say is unreasonable, and why do you say the particular period you propose is reasonable as opposed to that proposed by the IEC?
May I?
On the facts.
I will try to answer that in a second, but Chief Justice, may I, with your leave, touch upon something that would underlie the type of order that you've asked me about, and that is the appeal, because not unimportant, the order that is being sought to be appealed against, and were it to be found that the appeal would not succeed, for purposes of answering the question as to the 172(1)B question. On page 377, because the submission is the court would have to deal with the kinds of orders that were made by the electoral court in determining the 172(1)B just and equitable order. The first is, the 4 orders were made are found at page 377. The first, and one sees an amended order. The reason for the amendment, as I understand it, is that there were originally 7 wards that were sought to be the elections in 7 wards, and then as the papers developed, it only became 6, and that was the result of the amendment. That prayer 1 we would submit is moot. It's got no relevance for purposes of this court. Similarly, in respect of prayer 4, and as I understand it, the court has, subsequent to this order, made no orders to cost as a final order. So it's really prayers 2 and 3, or paragraphs 2 and 3 of the amended order, that is the subject of the appeal. The first is paragraph 2, which says that the certification of the voter's roll, which is the subject matter of this case, is set aside. So the first order of business for purposes of 172(1)B would be to protect the voter's roll despite it not complying with section 16(3) and come. There would have to be some kind of order under this 172(1)B broad remedial just and equitable jurisdiction that protects voters' rolls which don't comply with section 3. Otherwise, one would have the consequence that a voter's roll, similar to the Clockware one, would fall foul, and the whole election would be subject to the type of nullification that occurred in paragraph 1. Similarly,
would it be an option, while you're still there, to say it is a practical impossibility for the IEC to comply with section 16(3) in the time available? For that reason, 16(3) must be understood in this case to mean that those addresses are not available. But make an order that says, just thinking aloud, I haven't processed it, I must confess, this has been a very difficult case for me. 1, the IEC must do everything within its power to verify those addresses that are capable of being verified in the meantime. But more importantly, cut down on the 4-year period required. Maybe I'll understand in due course, but I've got difficulties with reconciling myself with the 4-year period. Reduce that period within which compliance with Section 16.3 would take place. With a result that come 2019, we have a common voters' roll that complies with 16.3 effective from 2003, accepting, of course, that there are places, if I may give evidence. Just on Saturday, I was talking to somebody in one village. He lives in a shack. I said, "What's your address?" He said, "I don't have it. They have not written addresses on our shacks." Accepting for that reason that some people simply don't have addresses, no number, nothing. And therefore, they are not those in relation to whom the IEC is required to provide physical addresses. Yes. Would something along those lines provide a model or the basis on which an order can be crafted?
The DA would support an order of that type, subject to one caveat. One of the serious difficulties that the DA identify, which is not on the papers, but it's in our heads of argument, is that by-elections by their nature are subject to the kinds of, let's call it, difficulties that Clockway experienced rather than general elections. By their nature, in a by-election or in a general election, the voter has one vote which he or she may cast in a particular ward. Let's assume there's a voter who votes in the wrong ward. Busing takes place, or so whatever the problem is. In a by-election, that voter who's now bussed doesn't lose his or her right to vote in his correct ward.
How can that be? Because when you vote now, there's a particular ink that they put on your finger. So if they have put that ink now on my thumb, and I go to another station during the electoral period, the people have got a scanner now, and I've tested this ink as well as you have. It takes some time to clean it up. How can the scanner not detect?
That's our point, Chief Justice. That's our very point.
So the busing doesn't arise, does it?
In a general election.
But in a ward, don't they use ink in the municipal elections?
Yes. So Chief Justice, I'm with you.
Yes.
I'm making a different point.
Oh, and that is
the difficulty in a general election, which is when all the wards vote at the same time, let's say on the 3rd of August, I would go to a particular ward, my finger would be inked, I wouldn't be able to go to another ward. And whether I was in the wrong ward or not, I would lose my right to vote in the correct ward. In a by-election, that problem or that mischief or that difficulty doesn't arise because it's only one ward that has an election. So I would arrive at the ward, I would vote, even though I wasn't entitled to vote at that ward. I wouldn't miss out. There would be no problem because I'd have an extra 100 or an extra 1,000, whatever the number would be, voting in a ward where they weren't entitled to vote.
I see your point. You're saying, and I'm just thinking aloud, if I wanted to disadvantage my political rivals as a party, I would check where am I stronger. And if I can bus people without losing that ward,
that's right,
I would take the extra people to some other ward so that even where I wasn't supposed to win, I can win.
Yes, and the reason we make the point, the DA, is to deal with, Chief Justice, your point about let's assume that the 2016 election goes ahead without addresses. But by 2019, the addresses must be there. The DA is very concerned about the by-elections that would take place, for example, between 2016 and 2019, because of that difficulty that effectively, Chief Justice, you yourself have identified.
And it's a problem we can't do anything about if the period doesn't allow. We can't do anything about immediately.
Well, we would suggest that you could, because part of your just and equitable remedial discretion could be, for example, to say when it comes to a by-election, by their nature, the work of the IEC is far less pronounced than for a general election. So one could give the leniency, as we call it, for this 2016 election, but for no further election.
I think we will then have to leave it to Mr. Trengove when he addresses us with the benefit of some information being passed on by his clients, whether it is a feasible option.
But I do want to put that as part of the...
Yes, no, I see your point, yes. Whether I agree with it or not is another story, but I understand your point.
So we would suggest...
Just before you go past there, let's just get something clear. Both Ermelo and the Van der Merwe cases make it quite plain that you have to find unlawfulness. The remedy is not available for asking. You have to find something wrong. It need not be a declaration of invalidity of a statute. What would we find unlawful here?
The IEC having failed to comply with their 16.3 duty from December 2003 to date. That would be that finding would be that from post-December 2003, there hasn't been compliance with.
That is very seductive, I think is the word. But let me tell you, the subject to what Mr. Trengove is going to say when he gets up his feet. Their position has been the addresses are not available. We have done nothing wrong. We have meticulously kept addresses from 203 if and when they were available. So how do we get to a finding of unlawfulness?
Well, I would like to give the court three answers in a sense. The first is, one, this court has already found that there was unlawful conduct by the IEC, at least in respect of Tlokwe, in the Cum judgment. So Mr. Trengove would be hard-pressed to say that the IEC has never done anything wrong because this court has found that it's done something wrong.
Mr. Marcus, he says the issue was 4,000 voters and the addresses were not available and there can't be anything wrong.
Well, if one looks at 5A of Cum, it is declared that by-elections conducted, and this was a rejection of the Electoral Court upholding the by-election, the court recalls. This court in 5A, it is declared that the by-elections conducted in Tlokwe on 12 September 2013 were not free and fair. There's no room to argue that there has not, at least in one instance, on one particular by-election, been a violation of the constitutional demand of free and fair election.
It sounds very attractive, but in fact, it's a little more intractable than that. I'm talking about historical lapses from 203.
Yes.
How do we come to the assistance of the IEC if its attitude is we have recorded as well as we could from 203? If we should have a concession or a fact that shows that. Page 422 shows us that there are about do I have the right page? Shows that there are about 5.5 million people who have not been registered. But I haven't had them concede that that number indicates people with addresses that are or may be available. So we have to get to a solution and we have to get to a remedy But remedy is not there for the taking. It is there when there's an unlawfulness.
I would borrow from Mr. Marcus in the Nkandla case, where he acted for the other chap tonight.
No, we don't have to get there. Shall we stick
No, his point was this.
Shall we stick to our knitting?
His point was this, if I understood it correctly, that even were in that case the President or Parliament to have misunderstood the law for whatever reasons, but they were bona fide, he relied on pharmaceuticals, that doesn't save the lawfulness of their conduct. So even if the IEC made every best effort and it perceived that it was complying with 16.3 in whatever manner it did, this court came to the conclusion that it didn't fulfill its 16.3 mandate. On pharmaceuticals, this court would be quite obliged, it would be obliged to find that that conduct was unlawful. And just, if I may pick up, if I may just for a second, if we read D in the way that we would suggest it's clear, the obligation on the IEC extended not just to post-2003 registrations, but to all registrations. And the IFP picked this up quite well, because they suggest, how many of us, 20 years later, are ordinarily resident in the same address that we had, for example, in 1998?
Carrying it far now, aren't we? Because you have to defeat the argument that says that there was no duty to keep addresses before 2003. If there's no duty and IC did not keep it, that's the end of that one, isn't it?
No, with respect. It's only the end of it as far as the potential unlawful or potential finding of unlawful conduct pre-2003. But once 2003 came along, then when a political party or candidate...
Show me the provision that creates a duty for the IEC to keep and disclose addresses. Before 2003. Before 2003.
No, before 2003, there was no duty on the IEC to provide addresses.
Oh, so we're in agreement, right? Okay.
Well, subject to the first sentence in paragraph 94 of COM, read with some of the questions that Justice Madlanga put, that there may well have, and this court doesn't have to go there, that there may well have been a duty under the Constitution to keep addresses for...
But do you accept that COM did not create any new law?
Well,
it sought to tell all of us what 16.3 requires, and 16.3 was made by Parliament.
That's right.
So we didn't create law, we didn't purport to. We just highlighted the duty that sits plainly in the section.
Correct.
Very well. So just my last point here is, what is your submission about what unlawfulness do you say we hold? Because if we do, it would be very unhelpful, because it will get us to a solution. If we don't, I'm afraid it will be quite a difficult conundrum.
The submission is, if I may just qualify, I agreed with Deputy Chief Justice, your question to me, when you put it to me, that all that COM did was clarify what the law is. I accept that, if that was your proposition to me. But I just want to clarify my answer by saying, to the extent that D mentions all future municipal elections or by-elections, we would submit, meaning can only be given to 5D if it includes all voters, not just those voters who registered post-2003. That would be our submission.
Application where available is right there in the order.
And where available as...
It's an echo of the law, that's all that it is. It's an echo of the statute.
Yes, no, we accept that. But we would submit that where available means not objectively verifiable, not on the basis of, well, as the IEC would put it, it's not on their system, therefore it's not available. That's their line. It's not on the system, therefore it's not available. And therefore they've complied. But that's their argument. The high water, low water mark, and the middle mark of their argument. We disagree. And if the court is with us on that understanding, that where available has an objective meaning rather than the subjective meaning which they ascribe to it, then we would submit that the 172(1)B remedy is available because they haven't done that which is required.
Mr. Katz, I'm sorry to interrupt you. Can I debate your reliance on Section 172 with you, because it really concerns me. Ermelo and Van der Merwe, can we start there? are not authority for the proposition that a court can order condemnation with non-compliance with a statutory requirement, or can order suspension of the operation of legislation. Do we agree there?
Well, as I recall the cases, they did not, this court did not order the suspension of the operation of a law for a period in those cases. But there's nothing in principle why the propositions or the findings of that court concerning the disjunctiveness, the disjunctive nature between A and B could not apply to, for example, the suspension of an operation of a valid law of Parliament. So that, for example, and why I refer to Van der Merwe in particular, is the first sentence of paragraph 59. The Chief Justice makes the point, in this case, in the Van der Merwe case, there's no law which has been found to be invalid.
I accept that. I accept that. Am I correct to say, Section 172, it is not a jurisdiction conferring clause? If you want to find the jurisdiction of the Constitutional Court, you go to 167. Supreme Court of Appeal, you go to 168. The High Courts, you go to 169. Are we agreed?
Agreed, we agree.
Okay.
It's a remedial.
And those sections, none of them say any of these courts, including this court, can suspend the operation of legislation. None of those sections say that.
Let me go back 15, 20 years where, for example, and it was, if I remember, Chaskelson CJ put the proposition to the government in that, to the UDM in that case. Let's assume tomorrow Parliament passes a law allowing for the death penalty. And before the law comes, and the law is going to come into operation in a month's time, whatever the situation would be. The debate centered around the following. Would it be appropriate for the court to strike down the law, as the High Court did in that case, without proper consideration of the issue, or would it perhaps have been preferable, which it was suggested in that case, for the operation of the law to be suspended pending something or other, pending the challenge to the law? Now, I understand that we're not in that territory in this case, but on the IEC's facts and on the assumption that the IEC did get it wrong in some respects, we would, as a matter of principle, suggest that this court should have no difficulty in suspending the operation of a law on the particular facts that are available in this case. Because if the court wasn't able to do so, and the appeal would succeed, it could have the effect of nullifying the entire election in August 2016, because the IEC, on their version, can't comply with the law for this particular election.
You see, my difficulty lies in there. What would be the source of the power that the court exercises? Because I said to you, if we have to check the jurisdiction of the Constitutional Court, we have to go to 167. If 167 doesn't tell us that, now we go to 172. 172 says a court that decides a constitutional matter within its power, okay, which is in line with what we have in 167. The Constitutional Court deciding a matter within its power.
Yes, and its power would be in 167.3. We would suggest. 167.3, sub 3, where the Constitutional Court is the highest court. B, may decide only constitutional matters and issues connected with decisions on constitutional matters. And plainly, we would suggest this is a matter Well, we would suggest it's a constitutional matter, and certainly the types of issues that we've been debating, if not constitutional matters, are certainly issues connected with decisions on constitutional matters, which kicks in the 172(1)(b remedial power.
No, I'm not saying this matter doesn't raise a constitutional issue. You misunderstood me. It does. The question is whether this court has the power to suspend a law that is in operation. That's my difficulty. And I say to you, 172 says a court deciding a matter within its power. Yeah. We need to find first, before we go to 172(1)(b, we need to find first whether suspension of legislation that is operating is within the power of this court. Yes. Isn't it?
Yes, and we would suggest, yes, thank you, Justice Jafta, that 167(3) would give the court the answer to that, that the power to suspend a valid law, parliamentary law, is certainly a constitutional matter. It's a constitutional matter, and then this court has the power, the jurisdiction, to decide that matter. Once this court has that jurisdiction, power, I take Justice Jafta your point, but we would suggest that we do have the power because of 167(3), sub 3, and then the question of what to do comes under 172.
Well, my last question was going to be, but I think you have answered it already, was going to be, doesn't 172(1)(b suggest that the just and equitable order that the court makes under 172(1)(b, it's an order that falls within its jurisdiction. It can't, yes, it can't do something that falls outside its jurisdiction. Therefore, if this court doesn't have the power to suspend an act of parliament that is in operation, it can't, under the guise of 172(1)(b, grant that order.
And that must be right, Justice Jafta. I mean, the point, I suppose, to answer the question is to say, well, when deciding constitutional matter within its power, of course, the issue must be within its power. In order to determine within its power, one jumps back to 167. And 167 does not preclude the court from suspending the operation of an order. If it's a constitutional matter, and it clearly is a constitutional matter, to suspend the operation of a valid piece of legislation in the particular circumstances of this case. So we would suggest the court has the power, the jurisdiction under 172(1) kicks in, and then B allows this court to do that which the IEC asked it to do effectively.
Finally, in respect of remedy, if we were to find that the IEC has not complied with section 16 sub 3, and we can't condone its non-compliance with that section, wouldn't it be a matter that Parliament can appropriately deal with?
I'm not sure that Parliament can deal with it between now and it's not just the 3rd of August, but if I understand the IEC's appreciation of the law, it's now, end of May, 3rd of June, they say. There must be a period of time before the election for the voters' roll to be certified. We know that as things stand, they can't, on their version, comply with the requirements, the lawful requirements of certification within that time period. And we would submit it could never be regarded as just and equitable that, for example, and the court has made it plain in the debate, that the option of a postponement is even on the table. So what are the other options? One of them is this question that I've been debating with you, Justice Jafta.
No, I was just putting that we're trying to find a solution, all of us here. I was just putting that in the event that we find the law does not allow us to fashion a just and equitable order which will facilitate the holding of elections on the 3rd of August. From now, between now and the 3rd of August, can't Parliament attend to the matter and even suspend? It has the power to suspend the operation of 16.3, doesn't it?
I haven't applied my mind, and I'd be hesitant to give a full answer to that question about whether Parliament has the power to amend its own legislation to have the effect of suspending the operation of its own legislation. It's not something that I've thought through.
Let me just, I need to explain myself. There are times when one judge puts a question, you answer, another one asks a question as if he's seeking to contradict the another judge. That's not what I'm doing. Is this a matter that will require the participation of provinces or not? I'm just trying to reflect on the time frame. Because if it's something that falls squarely within the power of the National Assembly, that's quite an attractive option. Can just quickly meet, amend, and that's it. But it may be problematic if there has to be consultation with provinces. Takes its own time. And then are you able to tell now whether it will involve provinces or not?
I can't tell now, but what I would argue is...
We will look at it if you don't have an answer.
No, but what I do want to say, Chief Justice, that were the court to find that the province's input was required, we would suggest that there's no reason why the municipalities and SALGA's input ought also not to be required. And that just would create a minefield of difficulties.
But back to the reason for my preamble, I need clarification. When a court has arrived at the conclusion that a piece of legislation is constitutionally invalid.
Invalid, sir.
Invalid, constitutionally invalid. It is entitled to suspend the operation of that section or legislation. So it is a power that it has within the context of Section 172. Now, if Ermelo and Van der Merwe permits us to make a just and equitable order in circumstances where there is no declaration of constitutional invalidity, but a conclusion has been arrived at that the IEC's conduct is unlawful in the sense that it ought to have provided addresses that were reasonably ascertainable and factored them into the common voters' roll. That's the unlawfulness. Do we, by reason of the power we have to suspend the invalidity of an act declared invalid, do we have, by reason of that power, to also suspend? I'm thinking aloud, that's why I need your comment. To also suspend, maybe even in certain respects, the operation of that unlawfulness of the IEC, even if it does not relate to a declaration of constitutional invalidity, with the result that we say, this is unlawful, but we're going to make a just and equitable order.
That's how we...
And this is the Mr. Katz type of just and equitable. Is it open to us? I'm not sure what the answer is.
We would suggest certainly. And one will recall that where the court suspends the declaration of invalidity in legislation, let's put it this way, the distaste that one has is that for a period of time there's unlawful legislation that's being implied.
That you are allowed to operate.
That's the point. That's the point. And there's no difference in kind with the kind of order that we are suggesting for purposes of this particular general election.
I'm not suggesting it. I'm just thinking aloud.
When we suggest it, Chief Justice, we suggest it, and let me put it this way: the DA suggested, on the basis of the facts that have been put up by the IEC, particularly in reply to the facts that we put up. because the DA put up certain facts in the answering affidavit in the direct access application which seemed to suggest that the IEC hadn't done everything that they could have to be ready and compliant with 16.3 for this coming election. And in reply, the IEC put up certain facts which it's not in the realm or the remit of the DA to deny. So it's only on that basis that we come with our 172 1B read with 167.3 for purposes of Justice Jafta's question, just an equitable remedy.
In line, before my brother comes in line with what I put to Mr. Bosman earlier, is it an option to be considered that parties be not ordered, we can't make any order now, but be encouraged, albeit informally, that they explore the possibility of arriving at a possible order that is acceptable to all of them, that will ensure that the elections do happen?
Yes. I think I made the point. The answer is yes. In a perfect world, we could be put in a...
But I forgot to add, not waiting for the other side to come up with a proposal. They work on theirs, you work on yours, so that by the time the two proposals meet, you know, a lot of spade work would have been done by both parties.
Yes. Perhaps Mr. Trengrove could answer better than I, but as I understand it, there are committees within the IEC consisting of representatives of the different political parties which have attempted this. And as I understand it, there has been some sort of stalemate, if I may, stalemate is the wrong description. There has been an impasse, that there's been a logjam. So that's why I make the suggestion of the IEC coming up with their order, and then whoever wants to respond to it can do so within a few days, depending on this court's requirement. And if Justice Madlanga was going to ask me a question, perhaps yes. I should just deal with something.
Yes, please. I'm interested to know whether, and I would like Mr. Trengove to respond to this as well, even if I forget to raise the question with him. I would like to know whether in a constitutional state where the Constitution, or where a Constitution is the supreme law, there is any room for the applicability of the maxim lex non cogit ad impossibilia. I'm sure you know what that is.
Not often that I can say to a constitutional judge that he's being sure was wrong. So although you're sure that I knew it means I don't.
The one case I remember, I forget who the judge was, but I think it was a matter that was argued by the late Chief Justice Mohammed as counsel. It concerned the limited time periods within which to bring an action against the police. And there somebody had been held in detention in circumstances where he couldn't give instructions to attorneys and so on. And when the police insisted, or rather raised a defense, the defense that you are out of time, the court applied this maxim. Basically, it means you cannot insist on the doing of the impossible. That's what the rough translation of that would be. So I'm asking, in a constitutional state where the Constitution is supreme, would there be any room at all for the applicability of that maxim? I'm not at all trying to counter the point raised by my brother Justice Jafta, but I'm just trying to get assistance from counsel.
Mr. Trengrove reminds me that it's Sinoli, if I remember the name of the case. But I think I'd like to answer it like this, off the cuff, without having had any thoughts percolating about the point. The answer is yes, but the court would still necessarily be restricted to 167 and 172. It would be a factor that would kick into the 172 1B type thinking. I would hesitate, and I haven't thought it through carefully enough, to suggest that that principle could apply despite 167, despite the power under 172 read with 167.3.
Clarify one aspect, Mr. Katz, in relation to unlawfulness and the fashioning of appropriate remedy. Section 190 of the Constitution imposes certain obligations on the Electoral Commission. One being that it must manage elections of national, provincial, and municipal legislative bodies in accordance with national legislation. B, to ensure that those elections are free and fair. Now, assuming that this case also applied to the post-2003, if we found that these elections were not free and fair, it would mean that the IEC would not have discharged its obligation in terms of the Constitution. In that event, will it be open to us then to grant a declarator?
This court, we would submit that the answer is yes, and this court has already done so in Cum. The answer is yes. May I just add, it comes back to something that has been niggling, I think, Justice Madlanga. In answer to you, Justice Nkabinde, we would submit that although this court did not decide it in Cum, the first sentence in paragraph 94 of this court's judgment, which seems to suggest that even before December 2003, the IEC, in not having the addresses available on the roll, would not have satisfied 191 sub B, read with section 19. So the court knows our... So perhaps I should read it. Perhaps I should read paragraph 94. This is the judgment of Wallace AJ for the full court. I can see force in the contention that in order for an election to be fairly conducted, it is necessary that the participants have available to them not simply a list of voters' names and identity numbers, but also some means of identifying and contacting them, of which the voters' addresses is the most obvious. And then there's reference to a case. But then he says, but it is unnecessary in the light of section 16.3 to reach a firm conclusion on this question. The simple point I make is this court doesn't have to decide the case now, and it didn't have to decide it then. But we don't want to be seen to be suggesting that it's only because of section 16.3, which it is anyway, that it's necessary for a free and fair election to take place, that the addresses are on the voters' roll. Well, made of, no, what are on the vote, that are on the voters' roll and be available to those who wish to stand for election, or who stand for election.
But will that not depend on whether prior to the 2003 amendment there was such an obligation?
There was an obligation. 190, the section that Justice Nkabinde, you've read to me, section 191B, to ensure that those elections are free and fair. And what this court didn't deal with, but suggested there's an attractive argument for that purpose, that to ensure that those elections are free and fair, not with whether 16.3 was there or not, the candidates for election were entitled to a voter's roll with addresses for the purposes that 16.3 is there for purposes of canvassing and for purposes of verification. So to have a free and fair election, with or without 16.3, let's say without 16.3, there needs to be the addresses available to the candidates for purposes of canvassing and then verification. That would have been the argument.
It is an umbrella provision, so you'd have to satisfy us that even prior to 2003, there was a legislative requirement for the provision of addresses.
Well, Justice Nkabinde suggests that it's an umbrella provision is correct, but it's also a self-standing provision. It's a self-standing obligation under Chapter 9 of the Constitution that is hoisted upon the Electoral Commission. They must ensure that elections are free and fair. Whatever the content of that might mean would depend on a case-by-case basis. But this court suggested that it's a fair contention that that requirement would not be satisfied were addresses not to be available for candidates.
Let me put it this way. Maybe I'm just complicating the question. In 1998, the provision required that registration should be in the prescribed manner. So it means prescribed in terms of the regulations. What did the regulations prior to 2003 require? Did they require that there should be addresses? The pre-2003 position?
So with respect, Justice Nkabinde, the word "and" appears after 191B. So the prescribed national legislation that you're referring to is a self-standing requirement quite apart from the assurance that the elections are free and fair. The elections must be free and fair, and there must be compliance with whatever the prescribed national legislation refers to. But this court doesn't have to go there
Mr.
because 16.3 is there.
Pardon? The Electoral Act prior to 2003. We know that there was an amendment in 2003. What was the position prior to 9/2003? Was there a requirement, a legislative requirement, requiring that addresses should be furnished? And if so, where?
No, there certainly was no legislative requirement. But we submit that there was a constitutional requirement, which is different. Self-standing constitutional requirement to ensure freeness and fairness, there was a requirement for it. That's the point that Justice Madlanga has been debating with various of the council throughout the day. And we would support the contention that in order to give effect to free and fair, addresses are required, quite apart from the existence or otherwise of Section 16.3. But there's certainly, prior to the introduction of 16.3, there was no legislative requirement of addresses for purposes of being provided to candidates for electoral office.
You were supposed to finish at 4:27. I know we are to blame. Have you not raised all you needed to raise?
I hope I have.
Yes.
I hope I have. As it pleases.
Thank you. Thank you, Mr. Katz. Mr. Kemp?
Justices, may I first...
I suppose I don't have to declare that you are my lecturer.
If one waits long enough, Chief Justice, one always gets your own back.
Well, Mr. Kemp, you're not my lecturer, but I wondered whether you need candles now. Can you see well?
I shall be brief, Justices. I want to deal with...
Before you do that, should we give you 10 minutes uninterrupted, 5 minutes, or no time at all?
Chief Justice, give me 10 minutes.
Uninterrupted.
I shall...
As you do that, indicate to us what is it that you're going to be dealing with.
I want to briefly address the issue of availability, what it means, the importance of the IEC maintaining addresses even prior to 2003. I want to draw your attention simply to what the IEC said in its papers concerning the issue of unlawful conduct. And then I want to very briefly deal with the proposed solution that we have suggested as the IFP on the basis of you entertaining the application by the IEC. We are here today because what the IEC seeks here is an order to allow them to present the 2016 voters' rolls without being confronted with defects relating to absence of addresses. They anticipate such a challenge that if they certify such rolls, parties are going to embroil each other and the IEC on that basis, relying inter alia on the decision in Ham's matter in both the electoral and in the constitutional court. And what the IEC in fact states to this court is we cannot really, at this stage, it's not possible for us to give the addresses of all the voters. And I will briefly indicate to you why that concession or that premise includes also addresses that were available to the IEC. As far as that is concerned, what we say is that the contention was that available means available to the IEC on its record system. We say whatever it means in section 16.3, it cannot mean that, because if it means that, then the IEC can simply decide what the extent of its obligation under 16.3 is by simply not putting it on their record system, or be tardy in putting the addresses on their record system. We say what available means is if the IEC has the capacity or the ability to provide the addresses the voter gave to the IEC, which premised its allocation of that voter to a certain segment of the voter's roll. In other words, it is implicit in the voter being on the voter's roll that he gave an address. And there's nothing magic about an address. An address is where you live. And we do know that the voters live somewhere. And they gave sufficient details to the IEC for it to decide in which ward these voters must be registered. So we say, if one then looks at the papers, you can see quite clearly what happened. If one looks at the papers and one looks at volume 5 and one looks at page 418, one sees
18 or 80?
418, sorry, Chief Justice, at paragraph 60.4, although there seems to be a sentence missing, what the IEC says is that it originally considered that it wasn't under an obligation to maintain a record or to keep the addresses furnished to it. That is extraordinary, both as a result of what my learned friend Mr. Katz said with reference to paragraph 94 of the Kham decision. But if one looks, for example, at section 15 of the Electoral Act, that allows parties to challenge the inclusion of a person's name on the voter's roll. The first thing that that challenger must do, he must serve that objection on that voter. Now one can see the dilemma. The challenger says, he doesn't even live anywhere in this ward. I don't believe that he lives here. I want to serve this on him. And he says to the IEC, that is my objection. Where can I serve it on him? The IEC says, we have no idea where you can serve it on him because we haven't got his address. It is implicit, we suggest, on the scheme of the Act from 1998 that the IEC would keep a record of the information, of the data, of the addresses that caused them to put a voter in a certain specific district. We say if one looks further in the affidavit that I've referred to, you will see that what the IEC admits, and if one looks for unlawfulness in the case in which there was an appeal, and which appeal is before you, the Electoral Court said the unlawfulness was in you certifying a role that did not meet the requirements of Section 16(3). And that, of course, is the problem that the IEC has come to this court for and asked whether you can grant the relief in the direct application matter. On page 419, you will see that the IEC says that indeed, even after the 2003, the IEC was not especially focused on ensuring that every voter's address was fully and accurately captured on its systems. And it says that was because prior to that, there were few requests for addresses from political parties, and that the increased focus on the addresses only arose in the last 2 or 3 years. That does not take away that you have there a concession that they were not, even after Section 16(3) was put on the statute book, focused in ensuring that they maintain the record and keep it available of each voter. If this court then seeks for unlawfulness, it can readily find it in that conduct. The IEC's problem is, and if one for 1 minute forgets that maybe it was self-created, the problem is that if one looks at the application of 16(3) in the light of these circumstances and in the light of these legal obligations, it cannot really provide by 31 May voters' rolls that contains all the available addresses. For various reasons, they had let slip of some of the addresses. You will see that in the passages that I've referred to, and if you read from page 417 to 422 of the papers in volume 5.
417 or 470?
417 to 422. You will see that the IEC says in 1998, when the Electoral Act was passed, they had some 18 million registration forms. But they say not all of them have survived until today. I assume that is the fire that we've been talked about maybe and some of the other things. But the point is they had this information and it was available, and now they are, as a matter of fact, on their version not able to provide all the addresses that they had been furnished over the years. And it is to combat that impossibility of complying fully with Section 16(3) that has prompted the special application where they seek for this court to say, well, seeing that you cannot comply with the letter of the law, we are willing to grant you the relief that you may certify the voters' rolls without full compliance with Section 16.3. And in that regard, what has been asked and put by this court to my learned friend, Mr. Katz, certainly provides the basis for this court being able to furnish or to supply a just and equitable remedy in the light of the fact that it is impossible to comply fully with the Section 16.3 provisions with reference to the upcoming elections. Everyone here is of the view that the elections should go ahead. In the light thereof, one must then look at the IEC's application and say, well, if we grant that, it must be granted in such a manner so as to ameliorate the fact that there has not been and cannot now be full compliance with Section 16.3. In our submission, and we've made a proposal which is fashioned on Section 320 of the Help America Vote Act, that the voters' roll must then be published without the availability of all the addresses. And the one way of balancing it and giving effect to one of the purposes of Section 16.3, namely to ensure that a voter votes in the right district and no one else votes in such a district, to have the system of those people who do not have addresses voting and the two envelope system that the IFB have presented to this court. It is one way of ensuring that the parties can post-election, because it is simply not possible to give effect to the canvassing purpose of Section 16.
Let us explore that. You've been very helpful in trying to find a solution. Let's explore that. You see, the difficulty with that seems to be that when a voter's name appears on the common voters' roll, that voter is entitled to vote. You need something to remove the name of that voter from the common voters' roll in terms of the law. And another complication comes up. I haven't quite reflected on it, but let me say it anyway. It seems to be the following. If in line with what appears at page, I made a note here, paragraph 61, page 419, if in line with that, I mean having regard to that, that the IEC admits that it has not been recording the addresses of the voters since 2003, then you are going to have to go through, I suspect, the whole process that they say it will take them very long to go through for you to be able to separate those whose addresses are ascertainable from those whose addresses are not ascertainable. How are you going to tell that this one has a physical address? What do? You complete the form upon arrival, considering that it's millions who have whose physical addresses have not been recorded. How do you deal with that?
Chief Justice, as I understand the affidavit, the IEC has identified the voters who do not have addresses on their systems, and they have identified those who have inadequate addresses.
Let's leave it at, let's confine ourselves to those who do have addresses, but there are some challenges. I understand their position to be that it's millions of voters whose addresses,
yes,
who have addresses, but addresses are not recorded. Now, how then, in terms of the IFP's proposal, would it be possible come election time to act in line with that proposal? What happens when you arrive and it's millions of you whose addresses are not there?
Chief Justice, as I understand the answer of the IEC, what they have been doing, they have 51,000 electoral officers.
52, I think they said, but it doesn't matter. Yeah.
I also thought it was 52, but I was corrected. But Chief Justice, be that as it may, if each of them deals with 20 voters on the day, that is 10 million. There are approximately 12 million, and one must be realistic about it. We're not going to have 100% turnout. It's unlikely if one is practical and realistic about it. It does not seem to be impossible.
How? No, but what do you mean? They say it's not possible. It's not practicable to do that. And we can't leave anything to chance. Elections must happen. Whatever remedy we fashion must be capable of implementation, must be capable of yielding the desired outcome, which is elections must happen. So how then is it going to work out on the IFP reasoning? How is it going to be achieved?
Chief Justice, as far as that is concerned, what is necessary is, of course, if there is to be such a system to compensate for non-compliance of 16.3, then this court will have to fashion some order in those terms, because the legislation doesn't obviously make provision for anything like that. But it seems, and it's our submission, that it is by no means impossible, even if the IEC has to take into employment another 20,000 persons for that day. It does not seem to us to be an impossible task to have a very short statement from that person. He has to show his identification document in any case. To complete that form will generally, and Chief Justice, I do not accept that because rural communities are involved that they cannot very concisely indicate where they live. It is not a difficult job. Indeed.
Is it not a difficult or is not an impossible task?
Chief Justice, if you ask most people, where do you live, they're able to tell you in a few sentences where they live. And in this case, what the system we suggest is then that data, what they convey there, is made available to the other candidates. And if they don't challenge it, it goes ahead and they add those votes, nobody knows who they come from, to the others.
Does your system not depend on the applicability of 7.2?
No.
Okay.
Chief Justice, as I understand 7.2, that applies to someone who's not registered.
So
we're dealing with people who are registered in this.
So your system depends on what for the removal of people from the voters' roll in which their names already appear?
No, Chief Justice, they are not removed from the voters' roll.
Conditionally.
They go there, they vote. What this system is designed to do is to give the parties who consider that these people may not have been duly registered a chance to object on that basis. If they don't object within a short period, then nothing of that sort happens. That person's status will in the end depend on whether there is a valid objection to him having been registered in that district. All that the system that we propose does is it allows the other candidates to, on an intelligible basis and with reference to specific addresses furnished to them, to establish whether there is any significant room for objection. And we submit that it is not impossible to do that. And if you ask me about the 4 years that we have been confronted with in which we have come here, I cannot give you any greater factual assurance that it can be done shorter, except a generalization that generally when there's an onerous task on any state body and they say they will complete it in 4 years, they can normally do it in 2 if it really comes to the push.
Let me just run this possibility through you, and then you can tell me how unworkable or objectionable you consider it to be. And that is an order that accepts that there is unlawfulness, in the sense that there has been non-compliance with Section 16.3. But then it also recognizes that after before we get there, and then requires of the IEC to do whatever is reasonably capable of being done in the interim before the elections are held, to get those addresses that can be reasonably ascertained, and essentially suspending the requirement that all the addresses that Section 16.3 requires that the IEC should have obtained from 2003 to date must be obtained before the elections can be held. So you suspend that partially. And 3, in line with, I don't remember whether it's Mr. Bosman or Mr. Katz, their concern relating to by-elections, you make an order that says all by-elections that will be held after the August 2016 local government elections must be held based on the voters' roll that complies with 16.3 insofar as it affects that particular district or those districts. Mr. Katz makes a point. He says, look, it's not for the whole nation that you'll be requiring this to be done. It's just a small area. So you can have all 62 of your employees, 52,000 of your employees in that area, cover it up and clear whatever needs to be covered. It's with that in mind that I'm raising this possibility. And then you say, as for the 2019 elections, the common voters' roll must be cleaned up say with effect by May 2018, with the result that when political parties begin to ask for the common voters roll, it complies fully with Section 16(3). All the resources that are required for the purpose of preserving the track record that the IEC has maintained over the years must be maintained, and that is to be done by cleaning up this, not within 4 years, but maybe 1.5 years or 2 years as the case might be. Would you find that to be objectionable, or does it provide the basis on which a solution can be found?
Chief Justice, any solution that and any proposal that compensates for the fact that parties have not been able via addresses to check registrations. Will and I do not recall any of the parties before you today suggesting that that would not advance the principle of free and fair elections. That is always a question of degree and a value judgment, but it is an obvious step that needs to be taken, if it can feasibly be taken, to advance that even in relation to the 2016 elections. And what you have put to me, the IFP would, that is why we are here today, and why we say that the relief that was sought from you by way of direct access was simply unacceptable, and the IFP had to come here to make its case on that. Because if it did not come here, it would be confronted, if it complained after these elections about the voters' roll, with the argument that we could not keep this objection in our back pocket. We had to put it before the court today. And that is what we're here for and what we have done.
But the cleaner route would, of course, be that proposed by my brother Jafta, which is, remedying a defective legislation is the terrain or the domain of Parliament.
Yes.
And saying to Parliament, this is your business, Section 16(3) comes from you, it has created this problem, sort it out. Is it a feasible option, maybe? Because it's the better of all, the best of all options we could possibly think of.
Chief Justice, I'm afraid if that happens and Parliament decides to suspend Section 16(3) in a blanket manner without compensating.
Amend it, maybe.
Yeah. Then, if I amend it, then I'm afraid there will probably be another day like today in this court on the basis of a constitutionality of that.
Mr. Kemp, does that suggest that your client has more confidence on this court than Parliament where it serves?
That is why we are here today and why we make these submissions. We do not enter into the fray on all accounts, and on the appeal, we simply say that insofar as the court followed the Ham decision, which we submit, if one looks at the order, paragraph 6, that says this relates to all future municipal elections, and one looks at paragraph 114 of that decision. one sees this court spelling out why it wanted it to be prospective, because it didn't want a challenge to anything done by the council that had in the interim operated in those areas, or any other council that had been elected in the past, any other municipal council. And we say it is quite clear that the requirement that the addresses of all voters must be given, in fact, relates to all voters. But obviously there must be a reasonable time for that to implement.
Mr.
Sorry.
Cap, you refer us to page 420.
4?
You refer us to page 420 and 421.
Yes.
It just struck me that the IEC tells us that they don't have the addresses, complete addresses of 65% of all registered voters.
Yes.
Only 1/3
That is correct.
of voters are, addresses are properly documented.
Yes.
And you invite us on that basis to find that they acted unlawfully.
What I am inviting this court to find is to allow them to use this voters' roll with these voters exercising their voting rights, but subject to a check and balance to make up for non-compliance with Section 16(3). That is the submission.
Okay, and in relation to the appeal, should we uphold it at all? In your approach?
It's our submission that you should not, Deputy Chief Justice. It seems to us that the court in that case simply applied the earlier decision of this court in that matter, and that in the circumstances of the case, especially given that it had been to this court before, and if one reads, the issue seems to have been about what does the prospective effect of this court's decision, and that is why the IEC felt quite confident in putting up that voters' roll that it had. And we submit that in the circumstances, the court below seemed to be quite correct in saying, well, if you want to put up a voters' list like that, then you must explain how it complies with Section 16(3).
And on direct access, I just want to wrap up clearly and understand in my own mind, and we should also refuse direct access, right? Or should we grant it?
Should you, sorry?
Because should we refuse or grant direct access application? Because if we don't grant it, we might not reach the remedy.
If you refuse the direct access, Deputy Chief Justice, then what is going to happen is that there are going to be challenges to the rolls, and it does seem in our submission a far better outcome for everyone involved if this court rather hears the direct access application and allow these voters. After all, it is not their fault that they're not properly registered, to vote and only balance it with a check on information that they do have. It is very few voters that actually cannot tell you where they live.
So in essence, we have to save the IEC from challenges against the voters' roll. 2/3 of the voters' roll.
Yes.
and that we should do by way of direct access.
Yes.
Yeah, I understand the point. Thank you.
Thank you, Mr. Kim.
Thank you. Sorry, Chief Justice, my learned junior has given me a note and said there's an issue of coordination. We filed the electronic.
We will reflect on it on the basis of your argument on papers.
And we do want costs of two counsel. We make that request because we came here on the basis of relief being sought from this court to suspend wholly for this coming up elections the operation and the effect of section 16.3, that must be ignored, and also that the proper compliance thereof was going to be postponed until after
we will deal with that.
Thank you.
And Mr. Kemp, this is not because you are his lecturer, but because you have put up a very good case, I must say.
Thank you, Valerie.
Mr. Trengove, can we have a 2 to 3 minutes break?
Certainly, Chief Justice.
Thank you. The court will adjourn for 2 to 3 minutes.
All right, those were live proceedings from the Constitutional Court in the urgent application by the IEC against an electoral court's decision that the voters' roll should have physical addresses. The lawyers for the electoral court have maintained that if the addresses of the names of the voters' roll are not obtained and elections go ahead, this would mean that the voters' roll itself is suspect, as those voters cannot then be tracked. The Chief Justice then inquired if there could be reasonable terms undertaken by the various parties to ensure that elections go ahead while the IEC gathers relevant details. And of course, the court has just taken an adjournment. We will be back with those details. And of course, the primetime business team will be here at 6 o'clock.
Struggling to manage. How do you say this thing is based on the 1963? You say that we've addressed constitutional
It's like a moving target, that's for sure. It's a moving target. You actually look at how they deleted 172. It's a moving target because you don't know what it is.
They dismissed you, and then 15 minutes later they remembered that, oh, by the way.
Challenge it there based on. You will accept everybody who addresses in the same ways you challenge it. You don't remove anybody.
Let's take a quick look at what's coming up in your headlines.
Good afternoon and welcome to A View from the House.
For all things news, tune in to Midday Report weekdays at 12 noon only on the SABC News channel.
Hayi ugogo sekaredi ke angisho fanele sibabikele abanikazi besigodlo noba sisishilo ke gogo.
My name is Dineo Undlanzi. Igama lami ledlozi, meaning my ancestral name Ugejani, Nsizwa kaShabalala. So I'm a trained Sangoma and prophet, and I do other healing modalities as well. I'm a Heal Your Life teacher, which is based on the philosophies of Louis Hay, just saying if people can take charge of their lives, they can really influence and create a better life for themselves. And I'm also a relationship coach, so I do coaching and a facilitator and a whole lot of other things. But these are connected to my healing abilities. There was an outreach program for kids who showed potential in township schools, so I went to St. Mary's Outreach, and I was showing a lot of potential. I got a scholarship to go to an American school, an academic scholarship. I was the only female that was selected. Things went haywire around that time. I think even before I left the school in Alex, I was slightly psychotic, because I remember one time my teachers coming to see my parents, saying they need to speak to me. I study hard. I did study hard. I read chapters ahead of my teachers, and I would always correct them. But they were worried that me reading hard was driving me a bit insane, because I used to tell them I see things and speak of predictions like this one will get in an accident. I don't remember any of that at all. So come 2000, when I was doing my matric, things got extremely worse. I was extremely seeing visions. I saw a lot of death, and at church I used to be prayed for a lot.
So what challenges do young Sangomas come across?
I think the biggest challenge is that nobody wants to talk to us. I mean, as young people, we're quite curious. We come from a different era, an era of intellect, an era of it's good to ask questions. So when we go into these things, when we ask, people do not respond to us, because Ukobelwam used to say, Dineo, you think you're too smart, But I was trying to create an understanding for myself, so that for me, this story is my own personal story. I'm not speaking on behalf of other healers. I'm speaking on behalf of Dineo's story, Dineo's journey. So for me, it was really trying to make sense so I can practice what I'm asked to practice with integrity. And I think that's the biggest struggle people are facing today. And the stereotypes around being a healer. People they find it very surprising that I'm a healer and I'm so articulate, because the messaging around it is we are illiterate, we haven't went to school, we don't know anything, we are dirty, we don't look beautiful. It's a practice that's looked down upon. It's nothing, it's not appealing, it's not representing modernity, success or anything. But like I said, it is shifting, because a lot of my clients are professionals. So because they realize, if nothing works and you've tried everything, you need to go back home. And where's home? In the Leabapant. I work in I do home consultations, office consultations. I come to you. My ancestors have allowed me to work in that way. And I think, ancestors are not out there looking down upon you, waiting to smack you or judge you or punish you. If you are able to have a good, proper conversation with them, engage with them, and you say, my work is to heal the world. So allow the channels that require of me to do so happen. Also, if we do not move with the time, we become irrelevant and we become extinct. So for me, is about spirit exists everywhere, and spirit has no barrier. It's humans that create barriers. So for me, means I did 2 weeks ago. I was consulting somebody from the States. So if they bring umuntu ofuna Skype, umuntu ofuna telephone consultation, uyagula umuntu uyafuse Zimbabwe. And they said, uzosizwa la ekhaya. So I can't say, no, asidili Skype, until elam lisho kanjalo ihlozi. That's what I'm saying, who's your CEO? So we are dictated by those who have blessed us with these gifts. The nature of my work, besides being a healer, is to always keep an open mind and not to put boundaries, not to put restrictions. Boundaries are important because they create a container, but not restrictions and never. I've learned that, Gogo. I normally...
To finish in about 15 minutes. But if you would, after that, allow her a further 5 minutes to address that remedy. I'd like to spend my time really on 3 topics. The one is the only cause of action that was raised in the papers. The second is the other causes of action that have been advanced today that were not raised on the papers, and why it would be unfair to the IEC to consider any of those causes of action. The third issue that I will address is the remedy that we seek in the direct access application, and merely the competence of that remedy, because that has been elicited much debate.
Can I put something else in your basket, if you allow me? Page 420 of your affidavit.
Page 120.
420.
420.
Tells us 32% of voters' addresses have not been captured. Then says 33% are incomplete or generic addresses. And says only 34% are complete addresses. And over the page in 421, the IEC tells us that it is clear that across the country, the IEC will be unable to satisfy addresses in the manner required by the Electoral Act judgment in respect of approximately 65% of all registered voters. When you find time, come to that issue and tell me why shouldn't we find that the IEC acted unlawfully and inconsistent with Section 16.3 of the Act. You can deal with that at your own time when it's convenient.
Certainly, Deputy Chief Justice. If I may start with the cause of action raised in this case. And remember, this case was an urgent application launched on the 22nd of January and heard on the 23rd. So the papers were prepared overnight. And the application launched on one day, on the 22nd. My client filed their answer the next morning on the 23rd, and the case was heard and decided on that day, the order made. So this was a highly pressurized, urgent application. And the issue in that application, I submit with respect, was a very, very narrow issue. And that was a contention advanced by the independents that the voters' roll provided to them did not comply with the COM judgment because there were 4,000 names on the roll without addresses. That was the contention. Now, if I may go firstly to the two letters that were exchanged in the days immediately before the application was launched, because the parties referred to them and incorporated them in their papers. The first letter was the letter of the independents' attorneys, which commences at page 55 of the papers. And the particular cause of action which they advanced in the application was set out at page 56 in paragraph 4. And this was what they said. Ex facie the contents of the voters' roll. The voters' roll provided to our client does not comply with paragraphs C and D of the order of the Constitutional Court, in that the following numbers of registered voters in each of the respective wards of the by-elections does not reflect a verified address. And there the numbers are given, and that is the 4,000 names without addresses. So the contention in that paragraph was simply, there are 4,000 names on the roll without addresses, and that does not comply with the COM, with paragraphs 5, C, and D of the COM judgment. The answer to it came in the letter from the IEC's attorneys in volume 3 at page 208 of the papers, but the particular paragraph is addressed from page 209 in paragraphs 8.4 to 8.6. And the answer at page 209 in paragraph 8.4 says, with regard to paragraph 4 of your letter, we point out that the Constitutional Court was at pains to point out that its order did not impose on the Commission the obligation to verify addresses provided by voters. And then over the page in paragraph 8.6, it deals with the contention that the COM judgment required every name to have an address. And what it says is the following. To the extent that the complaint in paragraph 4 of your letter relates to the fact that in respect of some of the voters appearing on the relevant segments of the voters' roll for the affected voting districts, no addresses have been provided, we are instructed that there are at least 2 reasons for such lack of addresses. 1, some voters were registered on the relevant segments of the voters' roll prior to the judgment without providing a conventional address. And 2, some voters were registered on the relevant segments of the voters' roll after 30 November, that's after the Kham Order 2015, who were unable to provide a conventional address. So the answer, the case made against them was Kham required all names to have addresses. There are 4,000 names without addresses, therefore the roll does not comply with Section 16.3. The answer is no. Kham judgment was prospectively made, the orders was prospectively made from the 30th of November. Some of the names on the list that you see without addresses are old names, not post-Kham. And insofar as some of them are post-Kham, those are people who do not have addresses. That was the debate. The application was then launched, and the application simply perpetuated exactly the same contentions. And it is made clearest in the notice of motion in volume 1 at page 2 of the papers. Because the order that was sought was an order declaring, that's in prayer 1, an order declaring the segments of the certified voters' roll of the by-elections to be held in the Tlokwe local municipality in those wards are not compliant with Section 16.3 of the Electoral Act, in that the said certified voters' roll does not contain the physical addresses of all voters. That's exactly the same case. It's a case that says Kham required the roll to include all voters, and because there are 4,000 absent addresses, the roll is non-compliant. That was the cause of action that was advanced, and that was also the...
I think one should read that whole of 1. It goes beyond that. All voters, alternatively, an indication that the said physical addresses could not be verified or established. That's the whole complaint in full.
Yes. Yes, indeed. But it fails to recognize that Kham does not impose a duty to include addresses in the voters' roll of people previously registered without addresses, people whose addresses were not kept and recorded.
Complaint requires an indication that the addresses could not be verified or established. It's an invitation to the IEC either to have them all there or to indicate why they are not there. Isn't that the two struts of the complaint?
No, with respect not. We accept that in relation to every voter that was registered, the address was determined and established. It is true that none addresses were ever verified, in the sense that nobody ever checked on the IEC, and that's also the point made. We had never had a duty to check on the address given to us by the voter. But we're talking about names that do not appear on the voters' roll, in respect of whom the IEC was given addresses at the time when there was no duty to keep and record their addresses. And that is frankly also how the Electoral Court understood that cause of action. In those, the Electoral Court's judgment in paragraphs 8, 9, and 12 make that clear. In paragraph 8 says, the complaint is that the roll did not comply with section 16.3. Paragraph 9 says, that complaint is made because there are 4,146 voters without addresses. And then paragraph 12 explains that the fact that there are those many voters without addresses, the 4,000 odd voters without addresses, that is in itself a fatal defect. 12 says the fact that they do not have addresses, the fact that there is common cause that they do not have addresses, this admission implies that there are indeed voters on the roll as before the Constitutional Court, who should not have been included therein. So it's a simplistic case that proceeds from the premise that Kham required all voters in the roll to have addresses, and simply because there are 4,000 voters without addresses, therefore the roll is deficient. And that, with respect, was the only cause of action that the IEC was called upon to meet at the time. The causes of action that was not raised and therefore not canvassed on the papers, but suggested at various times here today, is in the first place a cause of action that says, although you do not, there is no obligation on you to record historical addresses, i.e. the addresses of the 18 million pre-December 2003, you had a duty to record the addresses of new registrations from December 2003, and you failed to do so. That case was never raised against the IEC.
But the notice of motion recalls the requirement of 16.3 in so many words. You've just read it to us.
Yes,
Isn't it so? In Volume 1.
Yes.
The notice of motion says, an order declaring segments of certified rolls held there not to be complied with 16.3 of the Electoral Act.
Yes.
So it's slam bang in front of us.
No,
Why is it a new cause of action?
No, with respect. Because what it said is, you do not comply with 16.3 because there are voters on the roll without addresses. It is the cause of action, a cause of complaint that I'm referring to. They said there's a breach of 16.3 because there are 4,000 voters on the roll without addresses. That's not only what they said, but that's also what the court understood their cause of action.
Yeah, but why is that a new cause of action? It is right in front of us. They rely on 16.3, they say so, and say alternatively, you must tell us why there are no addresses. That is the cause of action, and that's what we're debating today.
No, with respect, not Deputy Chief Justice. The cause of action said, the cause of action contended that COM had held that all names on the roll must have addresses. That was the whole premise of the attack. And they say merely because there are 4,000 names without addresses, therefore you don't comply with Section 16.3. And that is what the Electoral Court found. It found that because you admit that there are 4,000 odd names on the roll without addresses, therefore there's a violation.
Sorry to interrupt, Mr. Trengo, but the Electoral Court's order echoes the COM order that echoes Section 16.3 that says expressly where available. So is it difficult, as the Deputy Chief Justice is doing, to read that as a complaint that you haven't, whether since before or after December 2003, been doing your duty as a commission?
No, but the argument there was the argument made by our learned friends today that where available means where available in the market. In other words, you had a duty to go back. Don't tell me about old registrations which do not have addresses. You have a duty to go back into the field and to find the addresses for all the voters. That was the entire premise. And it is true that it recites the language of 16.4, but that is based on a premise that's 16.3. 16.3 means that you have to furnish in the voters' roll not only the addresses of people registered since December 2003, but the addresses of everybody, because where available means where available in the field.
I understand that, and we will have to determine what where available means, because it's come up before us squarely now, whereas it hadn't come. But whatever the details of that, the complaint is of a breach of duty by the Electoral Commission of Section 16.3 in failing to supply addresses where available.
Yes, where available in that sense, available in the field. If you were to uphold that interpretation, in other words, that there was such a duty to obtain the addresses of those on the roll where that address is available to you in the field, well, then it is clear that the IEC did not comply with that duty, because it never went out in search of the addresses of people already on the roll.
Or reasonably available, as the debate between you and the Chief Justice and other council.
Let me make it quite clear. The IEC did not, before this judgment, go out into the field to find the addresses of people registered on the roll before December 2003. What it did after December 2003 is that it recorded on its system all the available application forms that it still had, some of the people of the 18 million, but it never went out into the field to find their addresses. So that if the court were to hold that the section means that there was a duty on the IEC to go out and find the addresses of those people where it was possible for them to do so, well, then the IEC did not comply with that obligation. They just never understood that obligation to mean that they were obliged to find the addresses of people already registered. And let me submit with respect that that is an eminently reasonable and the appropriate interpretation.
Listen to what they say, a side interpretation, page 419, paragraph 61. Yeah. Indeed, even after 2003, the IEC tells us, the IEC was not especially focused on ensuring that every voter's address was fully and accurately captured on its systems. This was because, until relatively recently, there had been very few requests made by political parties for the addresses of voters to be provided, despite the existence of 16.3. The increased interest and focus on addresses has only occurred in the last 2 to 3 years. This appears to have been partly as a consequence of there being more contested municipal elections. So out of their own mouths, they tell us that even after 2003, they didn't focus on ensuring every voter's address was fully captured. I mean, what should we make of that? I mean, we don't need interpretation because they tell us so.
Yeah.
And then thereafter they tell us, as a result of this, 2/3 of their people on the voters' roll have not full or proper addresses.
Well,
or proper address.
Yes. Well, what they say is that they weren't careful as they are today to make sure that every one of those people are registered. There was sometimes a time lag between the registration and the recordal of the address on the roll. But the case made against them has never been that the 4,000 are people registered after December 2003, but that they have failed to record their addresses. The case against them is one that says you must have all the addresses on the roll, and here are 4,000 people whose addresses you did not provide. And
Mr. Trango, on the formulation of the cause of action, could the applicants in the Electoral Court have been able to tell of the 4,000 people whose addresses were not available or furnished to them?
Yes.
How many were voters who registered before December 2003, and how many thereafter, so that they can formulate this cause of action properly? My assumption was that they didn't know. The IEC as well in its papers does not tell us of those 4,000 voters, how many registered before December 2003 and how many thereafter. It doesn't even tell us how many were registered after CAM. It does tell us that some were registered after CAM, but it doesn't tell us how many.
Justice Jafta, you're quite correct. The issue of when these people were registered, before or after December 2003, was not canvassed by anybody on the papers. I guess that the independents wouldn't know. I also guess that my clients would be able to establish, I think they can establish when a voter was registered. But that's guesswork because the issue was never raised and was never canvassed. You're quite right, but that, with respect, is because nobody raised that complaint. The other cause of action, the suggestion that one has to have the addresses for the election to be free and fair within the meaning of Section 191C. We submit with respect, firstly, that that's also not a cause of action that's been pleaded. The question of whether the addresses are a necessary ingredient of a free and fair election, that was never raised. And it's not an abstract legal question, it's very much a factual question. But, so the issue has never been canvassed. We submit with respect that it can't be a condition precedent for a free and fair election. Otherwise, it would suggest that all our elections before 2003 were not free and fair, because none of them were held with such a voters' roll. And if one were to ask yourself what the significance is, then we submit with respect that a free and fair election at national or provincial level can manifestly be held without an address list, because it's proportional representation and it's immaterial where the voter, in which voting district the voter votes. Ultimately, it's the totals that matter and not their distribution in voting districts. Location of registration matters only for local government elections. And there it does matter, it is significant. But the requirement there is that people should be correctly registered where they are resident. The requirement is not that address be in the voters' roll. I accept that the requirement of disclosure of the address would help to keep the voters' roll honest, because it would allow everybody to check the voters' roll. But to say that it is a condition precedent for a free and fair election, we submit with respect is unfounded.
The requirements of the address, doesn't it satisfy the requirements of ordinarily resident in 16.3?
The requirement of? I'm not sure that I'm with you, Justice Kambina.
Section 16.3
yes.
also requires that upon registration,
yes,
those people must be resident, ordinarily resident within the particular area.
Indeed.
So once you have the address, you'll be in a position to ascertain whether that requirement has been satisfied.
Yes, I accept that the address list is useful because it allows you to check on the accuracy of the voters' roll. I'm not suggesting that it is not a useful tool. The question is whether it is a tool that is necessary for a free and fair election. And I submit with respect it is not. It is a requirement that was introduced, as you made the point earlier. It's a requirement that was introduced when Section 16.3 was introduced in December 2003. The third cause of action, Justice Jafta, I'm not quite sure in what context you intended to refer to it, but you did make mention of the IEC's own acknowledgement of the 1,600 voters that it discovered were wrongly registered. And you're quite right. That is what the IEC acknowledged in its letter of the 19th of February. But what it made clear was that was part of its own initiative that it took after COM. It discovered that there were 1,600 people seemingly wrongly registered. It gave them notice that it intended to remove their names from the list, and only 2 people protested, and they were left on the list, and everybody else, 1,598 or whatever, were removed from the list. So clearly there was a significant problem in Tlokwe, and that problem was investigated and addressed. But that was done before this application was launched. So this application did not complain that there were 1,600 people wrongly registered in Tlokwe.
Just help me, Mr. Trengel. Does those 1,600 people have any relation to the 4,000 not registered with it?
No, they were taken off the roll before this application was launched. They had nothing to do with it. And that much is clear from the attorney's letter of the 19th of February. The paragraph was read earlier, but it is on page 211 of the papers in paragraph 8.10.5. It's made clear that they had already been removed from the role before the letter had been written, and therefore before this application was launched.
The debate, Mr. Trangove, was based on the assertion that the IEC in that letter says we have determined that the 1,600 people should be removed because they were registered in wards other than in those in respect of which they have given addresses, which suggests that it used the availability of addresses to determine whether those people were properly registered. Now, the difficulty was it doesn't say on what basis or what satisfied it in respect of the balance that they were correctly registered, even though the addresses were not available.
You're quite correct, Justice Chafta. They don't say that, but they were never. It was never a case that they were required to meet. That there's reason to believe that other people were wrongly registered, and therefore give us your justification for them.
Sorry, Mr. Tringo, we're squabbling with you at this late stage, but that complaint follows immediately after, in the letter you read to us. It follows immediately after. They say our own researchers have found these 545 other people. So reading the founding papers together, and together with what the Deputy Chief Justice quoted to you from paragraph 1 of the Notice of Motion, it does broaden the basis of complaint to say that we are unhappy about the non-compliance with 16.3 and with CUM because we're suspicious of all the registrations.
It is true that they raised the 500 in the letter. As I stand there, I'm very uncertain of my recollection of whether they raised that in the founding affidavit. My recollection is that it was not raised in the founding affidavit, that the cause of action with which they proceeded in the application was purely the 4,000 names on the list without addresses, and that they didn't raise a case, and that's the issue my learned friend Mr. Marcus addressed earlier. They didn't make a case in the application that there are, apart from the complaint about the 4,000, 500 people who have been wrongly registered on the list. They, in any event, never produced any evidence to substantiate that suggestion.
I struggle with this. I sit with half disbelief. IEC, a statutory body, it is challenged.
Sorry, IEC?
I sit with half disbelief, the submission. IEC statutory body, I think the point was made quite early by the Chief Justice. We're all fresh and early at about 10 o'clock. IEC statutory body is confronted with a notice of motion that says you have not complied with the law. You've breached 16.3. And we're worried about these 4,000 people. In one liner, they say we don't have the addresses available. They don't say, yes, they are entitled to be there. They're entitled to be registered there. This is how we know it. And therefore, your claim has no traction. They do none of all that. And you're still pressing on us that that was an adequate and legitimate response from a body which bears the duty to ensure, as we know from 8.3, read with 16.3. So how could that be adequate? How could that be a response that you say other people didn't do anything when it's IEC that bore the responsibility to say, these 4,000 will vote here, and I know why, because it complies with the law. And here are the facts. Not a scintilla of evidence that suggests.
No, with respect, Deputy Chief Justice. Remember, they receive papers today, and they're in court tomorrow. They produce papers overnight to respond to the accusation made against them. The accusation made against them is one that says that the effect of the Constitutional Court's judgment in Kham is that all the names on the list must have addresses. And if there is a name without an address, then that name is unlawfully on the list. That is the case they make. And it is true that the Commission didn't overnight research the origin of 4,000 registrations. What they did instead was to say, but your premise is wrong. You are wrong to say that the implication of Kham is that all names must have addresses. There are two categories of people who do not have addresses despite our compliance with Kham. As I said, we fastidiously complied with Kham, but it leaves two categories of people without addresses. The first is the old registrations, without telling us whether that means before and after 2003. They simply say, refer to the registrations that were not made pursuant to paragraph 5C of Kham. The second is those that were registered after Kham but who simply do not have addresses. So says the IEC to this application launched, dumped on it overnight. It says, the premise of your complaint is wrong. I haven't had time to, well, they didn't explain any further. They said the premise is wrong. To say that they should, in those hours between the 22nd and the 23rd, have researched and explained the registration of more than 4,000 voters is with respect to expect make unrealistic demands of it in an overnight urgent application. They had a short, complete answer to the premise on which the application...
The answer is they didn't have time. Not even to supplement, not even to hand up an affidavit in court.
Well,
they
bear
the duty...
They lodged this affidavit on the morning of the 23rd and they walked into court and the debate began. The order was made that afternoon.
They could have supplemented even before us. They could have supplemented in before that court. So the defense now is that there was little time. You see, the point I'm making from where I sit, if you bear constitutional duty and you are a state organ and you are challenged and charged with unlawfulness, you step up to show that you acted lawfully.
Well, in this court, what it made clear is that it had always complied with the law as it understood the law to be. And it explained that it understood the law to be that there was no duty on it to retain and record addresses before December 2003. There was such a duty since then, which it complied with generally, but not carefully and fastidiously, and that it has done so fastidiously since this court's order on the 30th of November. But what is important in that explanation is that it addresses two things. The first is the very complaint about the Tlokwe election that it said was based on a misconception. But, says it, if it was right and I am wrong, then it has vast implications for elections nationally. And that is when I come on my direct access application. That is.
And has IEC complied with the 16.3 obligations?
Yes, with respect it has.
The role, when you take the role and look at it now, do they need any assistance from us if they have complied? Why must we grant direct access?
No.
If in fact they've done everything squeaky clean?
Well, Deputy Chief Justice, what they have said is that they have always complied with the law and the requirements as they understood them. The matter as to how they complied since December 2003, how effective their compliance has been, was never canvassed in the papers at any length at all. You asked me to get instructions on that score this morning, which I did, and I gave you the best response that I could get within the minutes that we had available.
Till I discovered some valuable parts in the record.
No, with respect, that's unfair to the IEC.
I mean, through the IEC's own lips.
All it said there is that I wasn't as careful then as I am today, because it was not an issue that was pressing at all. And that the explanation that you got this morning was that there were sometimes delays between registration on the one hand and recordal on the other. But that is because we are debating an issue never canvassed on the papers at any length at all.
I'm getting increasingly worried, Mr. Trengov, because we were moving towards finding a way to accommodate the IEC, but it appears that the IEC is determined to take a particular position, and that is the position that seems to suggest that we have, from where we sit, we did all that we were required to do.
Yes.
Here is page 420. It's worrisome. From their own mouth, they say it's only just over 8 million people who were registered with addresses. We are not told, as far as I can recall, why is it that the other 8 million in relation to which there are challenges with addresses, and that something was not done? And if something was done, what is it? The banning of some warehouse in KwaZulu-Natal, does it appear here?
No.
Why is it not there? Because clearly, I'm sorry to speak long, but I'm expressing my maybe a bit of a frustration. You see, it appears that the IEC identified the need to clarify its position and to highlight its difficulties. That is why it was able to come up with numbers, 8 million plus there are addresses, another 8 million there are addresses but they are not complete or there are challenges in relation to them. Why is it, as a way of taking the court into its confidence, that the IEC did not explain why the other 8 million does not have addresses attached to it?
But with respect, it did, Chief Justice. What it said was, in December 2003, there were 18 million people on the roll without addresses because we didn't keep and record addresses up to that point. So your starting point is a roll with 18 million people without addresses. Since then, we have recorded the addresses, we have kept and recorded the addresses, but there still are two categories of people for whom we don't have addresses, and that's the 8 million and the 8 million. We started off with 18 million people without addresses in December 2003. That number had reduced to 16 million when this application was launched. Let me give the full picture. There were 18 million people on the roll without addresses in December 2003. By the time this application was launched, that 18 million voters on the roll had increased to 24 odd million, but the number of people without addresses was 16 odd million. So you had, despite a significant increase in the number of people on the roll to 24, there was 16 million left without addresses. And what it explained about those 16 million is that they fell into two categories of people. The one category was people registered before November 2003 at a time when we didn't keep and record addresses. That's the one category. The other category is people registered since then who do not have addresses. And that is roughly the 8 million and the 8 million. 8 million left of historical registrations and 8 million people who do not have addresses. So the explanation was given. I don't know that they could have given more explanations. What they could possibly have done, if they had been asked to do so, is to give the divide in that breakdown, a further breakdown of before and after December 2003, that they hadn't done because they didn't understand that to be an issue on these papers.
Well, let me tell you where my difficulty comes from, and it flows from what the Deputy Chief Justice raised with you much earlier. Page 420, paragraph 16.2. It says there are 8,314,822 registered voters whose address are captured on the IEC systems, or whose address captured on the IEC systems is either incomplete or generic. This includes, but is not limited to, what this court described in the CAM judgment as generic addresses such as Crossroads in Cape Town or Morningside in Durban. Now, incomplete, do we know why they are incomplete? Is there an explanation? When you are confronted with a problem, you seek to explain to those who are to adjudicate, you know what, I've got a problem. It was not deliberate. Let me tell you what my challenges were. Yes. I had this difficulty. I had this difficulty. That's why I find myself in this position. The paragraph that Justice Jafta earlier referred to, I understand that to mean, 16.3 is there, but we didn't understand it to impose an obligation on us. But at least some explanation as to why then, if it wasn't an obligation, were addresses of some 8,468,000 people captured properly and others not captured. That's what I meant by an explanation.
Yeah, but with respect, they did give that explanation. They said because there was no duty on us to capture the addresses before December 2003. So you'd have an address that says Crossroads. Now that's one of two possibilities. The one is that this is somebody who doesn't have a more particular address. They live in Crossroads in a shack which doesn't have an address.
That's generic, isn't it?
Well,
is that generic or is that incomplete?
Well, it can be either, because sometimes that voter doesn't have a better address than Crossroads.
I thought incomplete. I'm sorry, I'm interrupting you. I apologize to you, Mr. I thought incomplete is where the address is ascertainable, but for some reason, the one taking down the particulars did not complete the address, in which event there could be an explanation. Is there a difference between incomplete and generic, or is it the same thing?
No, it's not the same thing. But when I mentioned the example of somebody who said, I live in Crossroads, then it can fall into either of those two categories. It can either be a generic, purely generic, because the voter doesn't have a better address. He lives in a shack in Crossroads without an address, and he doesn't have a better one. And he was registered because he explained to the voting officer, the electoral officer, where in Crossroads he lives, and the long explanation satisfied the officer that he was registered in the correct voting district. That's the one possibility. The other possibility is that he lives in Crossroads, that he has an address, he lives in shack number so-and-so, but those particulars were not completed in his rec form. In other words, the rec form was incomplete in that it said Crossroads, and it was only on interrogation by the officer that they determined that it was a shack with a particular number which placed him within the voting district.
Or he or she forgot it by the time it was asked for.
Well, I don't know about forgetting, but what we are told is that a lot of people fill in their form in an incomplete way, and there is then a conversation between the registering officer and the person seeking registration, and sometimes that conversation discloses that the person has no better address, or it discloses that he has an address, but that record was not kept before December 2003. So that we submit with respect that the cause of action on which the IEC was taken to court was not established, because it was a cause of action based on an incorrect reading of COM. And the mere presence of names on the list without addresses does not say or suggest that there is a violation of 16.3.
We reach the direct access. If the appeal fails, we've had your submissions on the appeal. And if you go past there, how do we provide relief that your clients seek under direct access?
Well, if the appeal fails, then it means that the IEC had failed to discharge its duties under Section 16.3, And then the question arises what the appropriate remedy is for that failure. Now, it did not seek that remedy for the national problem in the electoral court because that was not the issue before it. And that is why it is here on direct access where it says, I say that the electoral court was wrong, but if I'm mistaken, if the electoral court was correct, then I have a very serious problem, a national problem, not a Tlokwe problem. And that is why I seek this court's assistance in addressing that problem. The appropriate remedy
is that problem. Let's just define it. We have to write the judgment. What
are
we going to say the problem is?
If the problem
say
is...
the appeal fails.
The voters, Section 16.3 requires that the addresses of all of the voters be included in the voters' roll where it is possible to obtain them. That is the implication of the judgment.
So the problem would be, in fact, unlawfulness, would be that it acted unlawfully.
Not unlawful registration, but unlawful roll. Unlawful 16.3, the roll that you disclose is incomplete.
The roll doesn't comply with 16.3.
Indeed.
Yeah. But we have to go there first, and then what remedy would we give them?
Well, then the remedy depends on where you find, precisely what you find the unlawfulness is. Is it because it seems in this debate that you may come to two different conclusions. The one conclusion, the extreme one, advocated by the independents and upheld by the electoral court, would be one that says there's a duty under 16.3 to obtain the addresses of all the voters, even those registered before December 2003. That's the one possible conclusion. And then the remedy would have to be designed to address that problem, and that is the assumption underlying our direct access application. There is another possibility, and that is that you find that there was no duty ever to find the addresses of people already on the roll in December 2003, but there was a duty to record all of the addresses registered since then, and that duty has not been discharged. Well, then it's a much more confined problem and a more confined remedy. Has not been canvassed on the papers because that conclusion has not been suggested until this debate. But there are those two possibilities. You asked us whether, Chief Justice, whether it might not make sense for the IEC and the parties to discuss the matter. I am told that my learned friends are correct. There are in fact committees in which extensive discussions have been had. But the problem is that until clarity is obtained on the question whether the IEC has acted lawfully or not, and if not, in what respect, it is not particularly helpful or possible for the parties to agree on a remedy if they don't know what it is that they need to cure.
What I had in mind was, as at the time when they found it difficult to find each other, they would not have had, they obviously did not have the benefit of the debate that we have had for the whole day. Now that the issues have been thoroughly ventilated, it may well be that upon further reflection, parties adopt a different attitude altogether to say, you know, coming to think about it, this thing is worth exploring. This possibility of finding each other is worth exploring. And I put it no higher than that.
I accept that is so, because the IEC would be amenable to a satisfactory outcome, even if they are not legally obliged to adopt that outcome. So that certainly a discussion we accept would be a meaningful endeavor. Could I address one last issue, and that is the issue of the competence of the remedy sought, because there was debate as to whether it's competent. May I submit with the greatest of respect that the remedy sought by the IEC would be competent under section 172(1) on one of two different bases. Firstly, because 172(1) empowers the court in any case within its jurisdiction to grant a just and equitable remedy, whatever it might be. And the case is within its jurisdiction if it raises constitutional matter. Once the case passes that threshold, the court has a broad power under 172, a remedial power, to grant any remedy that is just and equitable. And it has made it clear in the past that that's a broad remedy which it has not boxed in any way. And that remedy we submit would go a long way to allowing the court to regulate the process going forward in whatever way it deems appropriate. But even if the court were not to act under its general just and equitable power, even the specific power is one that can, the specific power relating to conduct that is unconstitutional is a power that would enable it to grant an appropriate remedy in this case. For this reason, if the IEC should have recorded and included those addresses in the roll under 16.3, then it means that it acted in breach of Section 16.3. Its conduct in providing a roll without those addresses is unlawful. Not only does it breach Section 16.3, but if it conducts elections in a way that does not accord with the law, then that would also be in violation of Section 1C of the Constitution, which requires the IEC to observe the rule of law. So its conduct in providing an incomplete voter's roll would constitute unconstitutional conduct. And this could, the appropriate remedy for this court would then be to declare that the IEC's disclosure under 16.3 of a roll which does not include these addresses that should be included is unconstitutional. But it may then qualify that declaration of invalidity by an order that says, I suspend that declaration of invalidity that declares its conduct to be unconstitutional. I suspend that declaration for as long as it is necessary for it to cure the shortcoming in its conduct. In other words, for as long as it's necessary for it to act constitutionally. So at the level of competence, the order we submit with respect can both be made under the general, just and equitable jurisdiction or under the power to suspend a declaration that conduct is unconstitutional.
Mr. Trangov, I think the debate arose from the proposal by the minister.
By the minister?
By the minister, that we should suspend the operation of the Act. It was in that context that the debate arose. And the question was, do we have the power to suspend the operation of an Act of Parliament? What you have just articulated is different.
Yes, it is. And
you'll be happy to know that at least there's one thing I agree with you for today.
Happy and surprised, let me just say this, Justice Matlanga. You spoke about the rule that the law does not require the impossible. And let me say that that rule, which is really a rule of interpretation, does play a part in one respect but not in another. It assists us in the interpretation of Section 16.3. We submit that it means you can't interpret 16.3 to mean that the IEC must record and provide not only the addresses of new registrations, but of old registrations, and do so overnight, because remember 16.3 kicked in December 2003. So the rule assists one in the interpretation of 16.3. Where the rule doesn't help, or doesn't help us, is that the rule doesn't excuse self-made impossibility. So if we're wrong, if we ought to have recorded those addresses, the old addresses, but failed to do so, then we can't ask you to manipulate the law to accommodate our impossibility. What we can still urge you to do is when you exercise your remedial discretion, when you make a just and equitable order, it is never just and equitable to require the impossible. So in the design of your order, it is important that you design an order that can reasonably be achieved and not something which is impossible. My learned friend, Ms. Blizzard, lastly will address the IFP alternative proposal, because we do submit that it's both unlawful and impractical. Those, Chief Justice, are my submissions.
We've been asked for costs from all sides. That is, if you lose, everybody's been asking for costs. They must follow the result, surely, shouldn't they?
I beg your pardon?
Should costs follow the result? Various respondents have asked for costs. I'm just asking. Is there any reason why costs should not follow the result?
No, I can't contend that there is reason to make an exception to that rule, no.
Well, maybe we should just, before we finish, find out from National House of Traditional Leaders and the minister can't ask for costs.
With respect, the party is entitled to costs.
No.
Would only be those who opposed us, not those who supported us.
They would have lost as well. I think you have a point.
No, I mean, the question is why those costs? Costs follow the results. Successful parties get their costs against the unsuccessful parties. If you find against me, you'll also find against the minister and against the ANC.
You're in the same block.
And there's no reason why the cost shouldn't go against them as well. Yeah.
No, you are right. Thank you. Ms. Blizzard, your 5 minutes. Mr. Trengrove, we cost him to take 35 minutes, but we are to blame.
Thank you, Chief Justice. As Mr. Trengrove indicated, I'm going to address the IFP's provisional ballot proposal. I'm not going to address the independence proposal because I accept that it's been conceded that that proposal is not a lawful option. If I may just start by summarizing what we understand the IFP's proposal to be. Essentially what it is that it envisages allowing millions of registered voters, lawfully registered voters, but who do not have their addresses on record with the IEC, to cast only provisional ballots. And then requiring that these millions of voters, many of whom will be illiterate, to complete a fresh voter registration form on voting day. And then thirdly, that the addresses of these voters must then be collated by the IEC and published to allow for a public objection process to unfold in terms of Section 15 of the Electoral Act. So I'm going to just address briefly the practical difficulties with the proposal and then the legal difficulties. So starting with the practical problems, in its replying affidavit, the IEC highlighted several difficulties in response to the IFP's proposal. And quite frankly, these difficulties have not been meaningfully addressed by the IFP. And really there are four practical difficulties. The first is that the IEC explains that to allow for a provisional balloting system like the IFP has proposed would require an additional 40-odd million distinct and security-coded provisional ballots to be generated, and that there's simply not enough time in the election timetable before the local government elections for this process to unfold. And that hasn't been addressed at all by the IFP. The second problem is that the voting process on election day will be seriously delayed if what there are presently 12 million voters without recorded addresses, and that's about 45% of all voters, if they are required to complete a fresh registration process essentially on voting day. And as we've explained, many of those voters will be illiterate. There are voters whose addresses are not on record with the IEC because they have no formal address, so they're not sophisticated voters often. And so they will need dedicated assistance to complete that registration process. And the IEC has estimated in its reply that conducting this mass re-registration process on voting day will delay the voting process by about 4 times, and that will in all likelihood deter many lawfully registered voters from exercising their right to vote altogether. The IFP's answer to this is that, well, all 52,000 electoral staff can assist these voters in this registration process, but of course that ignores the fact that there is also a voting process going on at the same time. The third problem then is that the Electoral Commission will, after voting has been concluded, but before the counting can commence and before the election results can be announced, the Electoral Commission will have to compile a list of 12 million voters who cast a provisional ballot. They'll have to publish the relevant segments of that list at each voting station. And really the scale of this exercise shouldn't be underestimated, and I think it has been underestimated by the IFP, who haven't really addressed our concerns in this regard. If one just considers that there are 12 million voters in this position, if we have just 100 names per page, you're looking at 120,000 pages. That's the scale of the list. Another comparator is the time periods that the IEC has proposed in its 8-phase process. Its phase 4 estimates that 3 months would be required for a similar mechanical process of capturing the address details of all voters on the roll. And then fourthly, there is the Section 15 objections process, which we say would take possibly months to conclude, given the scale of the exercise, and that this would imperil the integrity of 22,000 ballot boxes, which would have to be safely secured and kept secure over this period. And that concern has also not been taken seriously enough, and certainly hasn't been credibly rejected. So that's the practical problems. There are also legal issues. And here I would really just echo what the Chief Justice was saying earlier today, which is that public bodies must exercise powers that they have under statutes, under governing statutes. It's no good for the IFP to point us to an American statute to say that this is a lawful process. That goes without saying. The real problem really is that the Municipal Electoral Act, and in particular Section 7 and Section 47, entitles every person who is registered as a voter on the certified segment of the voter's roll to vote in the voting district where they are registered. And really what this means is that once a voter's name appears on the segment of the certified roll, he or she is entitled to vote. In that voting district, there's just no provision for provisional voting system. And I'm not going to take the court to the provisions given the hour of the day, but I would just alert you to section...
And your time is up. I'll give you
right.
one more minute.
Right, so it's Section 7.1 and Section 47. There are other technical legal problems that arise relating to how it would interrupt the counting process, it would delay the announcement of election results, and that too would be in violation of provisions of the Municipal Electoral Act, but that is all set out in our reply in our heads. So that is it. Thank you.
Thank you very much, Ms. Blissett. And all I can say to the parties is nobody can ever force you to agree, but it's an option worth pursuing, that possibility of finding each other. Otherwise, judgment is reserved and the court will adjourn.